respondent number 9 and 11.
I am for the petition that Mr. Prosenjit Mukherjee John is doing short passover.
What is this case? What is the case? What is the grievance?
Great for unauthorized construction. And they say, well, the Panchayat Pradhan himself was pleased to issue notice that it is unauthorized, it is to be removed. Subsequently, the SDO issued a notification and SDO said, no, it will be looked into by me as per the amended act, section 23, subsection 5 of the 2017 amendment of the Panchayat Act. And the petitioner challenges the same, saying that
Also, let me start, Lordship.
One second. You are not there. Lordship has asked me to press the case.
Oh, I am not there, so I have no right. Ready.
Please ascertain what has happened.
It again next speaker again.
It
If you start like this, then it becomes difficult.
Lordship,
I asked your friend what is your case. Now he says that Mr. Mukherjee will address the court. In the meantime, when you are coming, I asked him what is the case.
Also, I'm
If
sorry.
this is a fault on the part of the court, then I am adjourning.
No, I am not saying that. Lordship,
Why are you arguing with your friend? Why? I have asked him that what is the fact of the case. Since he could not apprise the court, what is the fact of the case? If it is a fault on the part of the court, then I am adjourning.
No, I am not saying that, Lordship.
Please don't argue like this. This is not expected. Yes.
Then he challenges the notification issued by the SDO and the minutes of the SDO, saying that it is contrary to the notification and the notices issued by the Panchayat.
Okay.
And he relies on the notices and the minutes issued and adopted by the Panchayat Pradhan, not the Gram Panchayat itself, which is contrary to the statutes.
Okay, Mr. Mukherjee. Yes.
Lordship, last occasion, Lordship, I have started that required notices were issued to the concerned persons who raised the unauthorized construction, and Lordship, demolition order was passed. Lordship, kindly come page 52. 52 of my writ petition.
The private respondents, you are representing all.
So, no, I am for the respondent number 9 and 11.
Your grievance is again 9 and 11.
10 is also
Yes.
there. 10 is also there. 10 is the brother of 9 and 11.
He has been served, Mr. Mukherjee.
Lordship, all has been said.
Topon. So you are 9 and 11.
9 and 11.
Polas and Ranjit. Okay. Page 52 is?
Yeah, Lordship, first of all, Lordship, this plot, particular plot 641, 642 and 643. Lordship, earlier occasion I have, Lordship, produced the document that the Panchayat is maintaining this land as a road, and Lordship, Panchayat has spent the substantial fund for construction and maintenance of the road. Now, encroaching this land, Lordship, this private respondent raised the construction, not only that's on the road, Panchayat road, but it is also fact that this road, this construction is without sanction plan. Now, Lordship, kindly come page 52.
Yes.
So page 52 is a demolition order, self-demolition order issued by the Pradhan against the persons who raised the unauthorized construction. That is page 52. Now, Lordship, page 53 is also the same letter. Ultimately, Lordship, the resolution has been taken by the concerned Pradhan. That is page 59. That this is illegal construction. Now, Lordship, concerned Pradhan, Lordship, the requested the concerned officer in charge, that is the page 61.
In which part of 59?
59 is the resolution part.
So where the Pradhan, the resolution, in which part it holds that this is illegal? Yes.
Kindly come left portion. Plot 641, 642, 643. Page 59, yes, page 59.
This right hand side,
Left side, 59 left side.
641,
উক্ত আলোচ্য সূচিত অর্থ গ্রাম পঞ্চায়েত গুইচা গ্রামের বাসিন্দা পলাশ মন্ডল সাচ লর্ডশিপ প্লট নাম্বার সাচ ইট সিমেন্ট একটি নির্মাণ কার্য করিয়াছেন যাহা জনসাধারণ যাতায়াতের বাধা সৃষ্টি করিয়াছে। লর্ডশিপ গট ইট? So, Lordship, this is the resolution has been adopted by the concerned Gram Panchayat that there is an unauthorized construction. Not only this is unauthorized, but obstructing the Lordship ingress and egress of the general people. Now, Lordship, the concerned Pradhan, page 61, that is the letter to the officer in charge, Mollarpur Police Station, for supplying the police station, police assistance, so that demolition can be, Lordship, made. That is page 61.
Page 61, yes.
Page 61 is a letter of the concerned Pradhan to the officer in charge, Mollarpur PS, Mollarpur Police Station, Birbhum, Lordship, for police assistance so that demolition can be carried on.
Yes.
Now, Lordship, all this letter was issued on 4th November 22. On 17th November 22, the block development officer, I don't know under which law, Lordship, he has written this letter. Block development officer has directed the Pradhan for suspension of removal of illegal construction. Lordship, under the Panchayat Act, the BDO has no authority to, Lordship, stop illegal construction and directing Pradhan to stop illegal construction. Under section 23, nor under the, Lordship, the administrative rules of 2004, the BDO has no authority, but BDO has issued this letter.
They have done one of these. This is violation. Now he has acted on the letter of BDO and referred the matter to the SDO.
Now, Lordship, I have referred the matter to the subdivisional officer, that is page 64.
Yes.
Lordship, this is the, with a kindly come the second page. They have done an half day's bricks and cement construction probable dark number such and such jail without sanction plan. Lordship, got it? Page 64, second paragraph, second line. From the concerned author, the GP on undivided co-sharer plot of land in excess of the share, such and such. I am not concerned with the share. No previous permission. Kindly come paragraph 2. No previous permission was obtained from the GP as per mandatory provision of section 23 subsection 1 of the West Bengal Panchayat Act 1973. Even no application for the same form made for sanction according to law rule 17 of the West Bengal Panchayat Administrative Rules 2004. The construction is done with clear intention to block only way two houses of few families to their ancestral house of the Bastu land. Hence, the said construction obviously will injure and impede the interest of the neighboring people, etc. Observing such and such, Lordship, notice under section 26(3) of the hearing and asks the premises that they are such and such, such and such. So, Lordship, this was the letter of the concerned Pradhan to the concerned subdivisional officer. Now, concerned subdivisional officer has directed the block development officer BDO 1 to conduct an inquiry. Now, let's say, first of all, this inquiry which has been done by the block development officer is lacking jurisdiction. BLRO can, Lordship, conduct an inquiry. Whether the block development officer, under the law, there is no right to the block development to conduct an inquiry, but inquiry has been conducted. As per the direction of the block development, Mauritius and development block received on Ato, inquired the matter, presence of Topon Mondol, such and such, I inquired the disputed land, found that a cow shed is standing up to Linton level. I asked all
Page
this.
number, page number.
Page number 767.
Yes.
I inquired, I'm reading from page third line of the first paragraph. I inquired the disputed plot and found that a cow shed is standing up to Linton level. I asked all the three persons stated about the permission from the concerned Pradhan of Jikirda Gram Panchayat regarding permission of Pakka construction. The cow said, but they failed to show necessary permission which is required for any Pakka construction. In this connection, it may not be noted, no persons representative Pradhan such were present during the time of spot inquiry, though the concerned Pradhan has been asked verbally to remain present on spot during the time of inquiry. Now, Lordship, this was the inquiry report. Now, Pradhan also, Lordship, submitted a report. Now, Lordship, kindly come, the impugned order. That is page 72. Lordship, first of all, Lordship, in this matter, in this hearing before the subdivisional officer, the complainant was not given any chance of hearing.
They were not given notice.
No. Lordship, kindly, today following persons were present in hearing in connection with the hearing: subdivisional officer Rampura, Lordship, the Susanto Kumar Maiti, block land and land reforms officer Pradhan, Polas Mondol, Ranjit Mondol. So petitioner, who is the complainant, has not been given opportunity to appear before the concerned subdivisional officer to participate in the hearing and to substantiate their complaint. Now, today's hearing is being, Lordship, may I read page 72?
Yes. Yes, read.
Lordship, today's hearing is being conducted due to submission of the letter by the Pradhan Jikirda Gram Panchayat, where he was informed that on plot number 641, 642, 643 of Mouja Buicha jail number, 3 persons, namely Polas Mondol, Tapos Mondol, and Ranjit Mondol, are constructing new structure without obtaining prior permission from the Gram Panchayat, with the intention to block the way of to houses of few families, and the construction will injure the interest of the neighboring people. It is the case of violation of section 23(1) of the West Bengal Panchayat Act 1973. And so the Pradhan has referred the matter to the SDO Rampurat for taking steps as per section 23(5) of the Act. In this regard, Mr. Susanto Kumar Maiti, DMDC Rampurat, has sent to the spot for field inquiry and to submit the report. Sri Susanto Kumar Maiti has submitted a report, and it reveals from the report that plot number such and such is a kacha pathway for walking neighboring people. In one side of the path, an open drain has been constructed by the Jela Parishad Birbhum, and on the other side, a cow shed has been made by the family of late Ajit Mondol and late Biren Mondol. plot number 641 consists of 0.2 acres of the land with classification VT, that is the homestead land. And as per the LRROR, owners of the plot, Ajit Mondal, Biren Mondal, and other 6 riots. The newly set structure is a tin shed stood in the brick pillar, and 2 sides are open, covering area less than 18 square meters. If the Gram Panchayat is to construct the CC road on the plot, there should be at least 5 feet wide vacant road, and also open drain should be covered by the concrete slab. The land is private Rayati land, and to construct any CC road, steps should be taken by the Gram Panchayat as per section 44 of the West Bengal Panchayat Act 1973. Now, considering the letter of the Gram Panchayat Pradhan and after field inquiry report, it appears that as per the provision of section 23 of the Act, the permission granting authority is the Gram Panchayat, not the Pradhan. So, there must be resolution taken by the general body to effect that the said construction was unauthorized and then referred to the subdivisional officer. But in the letter of the Pradhan, this matter is not clear. Let's say, first of all, this is contrary to the records, the resolution has been taken by the concerned Panchayat, all members. This factual finding of the subdivisional officer.
This is a wrong finding. Because you come to the letter of the Pradhan, which he has referred to. He says that in the second page, at page 65, hence Panchayat passed a resolution, top of it,
65, man.
65, which has been addressed to the subdivisional officer. So he cannot say that no resolution was passed. Yes.
Now, this is the contrary to the records. Must a non-requirement of the permission of the case of a hatch shed, structure, tin shed, etc. as per section 23(2), the said act should be also considered in the case by the Gram Panchayat. Lordship, the concerned subdivisional officer entered into the factual finding authority. Section 23 said that any concrete structure is permission is required. Lordship, this Pradhan fact-finding authority has considered that this is an illegal construction. The subdivisional officer sitting in a jurisdiction of section 23(5) cannot enter into the factual finding authority's observation. When the Pradhan said it is an illegal construction, the subdivisional officer has to consider this factual finding authority in toto. He cannot go. Lordship, kindly come section 23.
23(6).
Now, first of all, kindly section 23(1). No person shall erect any new structure or new building or new addition or structure of the building having plinth area of not more than 150 square meter. This is more than 150 square meter, and height not more than 6.5 area in any area within the jurisdiction of Gram Panchayat, except with the permission of in writing from the concerned Gram Panchayat, provided that where the state government or an authority of agency under the state government intends to set up or has set up the industrial estate or industrial park, not relevant, Lordship. Now, kindly come, provided that such erection of the new structure or a new building or such addition or structure of the building or such permission from the Gram Panchayat shall be subject to the rules as the case may be made by the state government in this behalf, provided that also the Gram Panchayat shall not accord permission for erection of the new structure or construction of a new building if the proposal of such erection or construction as the case may be has any provision for erection of the construction of any dry latrine or such and such, does not have any provision of erection of construction of a sanitary latrine or a description. Every person seeking permission under subsection 1 shall make an application in writing to the concerned Panchayat, provided no amount in whatsoever name, manner, other the fees prescribed. Now, next proviso, provided further that there shall be no restriction to covered area of construction, kacha, semi-pakka residential building, which mean a single-storied building not having the roof and brick, and with the said not less than 9/10 meter of the roadside. This is more than 9/10 area of the roadside. Provided that no permission under subsection shall be necessary subject to permission self-declaration for erection of any new hatch structure, tin shed, tile shed, without brick wall. Without brick wall. So this is admitted fact. This is a brick wall. Provided that Lordship state government may for the exempt any structure. Lordship, this is another thing. Now, Lordship, kindly come section 3, subsection 3. On receipt of such application, Gram Panchayat, after making such inquiry, examining the building plan as it's considered necessary and in accordance with such rules as may be made by the state government in this behalf, shall by order in writing either grant permission or refuse it, recording in the case of refusal the reasons therefore. Any person aggrieved by an order of the Gram Panchayat, Lordship, refusing, this is different. Provided that any person aggrieved by an order of the authority may prefer an appeal. Now kindly come 5. When any new structure or new building or any addition or structure of the building is binding or is being and or has been erected or made in the case may be in contravention of the provision of subsection 1, the permission granting authority shall refer the matter to the subdivisional officer concerned, who may, after giving the owner of such building an opportunity of being heard, make an order directing the demolition of building or a portion of the building as the case may be by the owner within the period that may be specified in order in default. The subdivisional officer may itself effect the state government and recover the cost thereof. Where any, now 6, where any structure of new building or any additional structure of the building being has been erected or made, as the case may be in contravention provision of subsection 1, the authority may, after giving the owner and such opportunity of being heard, make an order directing the demolition of the building by the owner within a period. Lordship, we have exercised our right, the Pradhan has exercised their right under subsection 6 and referred to the subdivisional officer. Subdivisional officer is mayor, will see whether there is any finding of the Pradhan regarding the unauthorized construction. Cannot, Lordship, revisit the validity of the order of the Pradhan. My first ground of this, Lordship, the writ petition. Now to construct, now kindly sees the clause 3. Construct the CC road in the said plot, steps to be taken of the Gram Panchayat authority as per the provision laid down in section 44 of the Gram Panchayat. After settlement of the matter as per the 44, Gram Panchayat will have to take steps for construction of concrete slab for covering the open drain. The Pradhan Jikita Gram Panchayat asked to hereby consider the above observation and to act accordingly after giving ample opportunity of being heard to everybody concerned present in the hearing, and lastly, conveying thanks to all hearing and concluded. Now, Lordship, this is under challenge. Lordship, this issue neither has the demolition order, neither has been, Lordship, the set aside. First of all, Lordship, if it is a order of remand, the Pradhan will again revisit the issue. The authority has to cancel the order of demolition. Subdivisional officer, Lordship, this is the law. If any authority wants to send back the issue on remand, this order has to be, Lordship, considered as an invalid, and this order has to be cancelled, and then it will be remanded back to the fact-finding authority. But the subdivisional officer, without considering the fact-finding authority, has remanded the back without considering the validity of the order of the Pradhan. Now, Lordship, this is my, Lordship, challenge of this minutes, Lordship, in this writ petition. Lordship, I am relying upon some judgments. It's so busache. Plus, I'm relying upon some judgments, that is by the Honorable Coordinate Bench. 8 September 2021. Lordship, kindly consider this judgment. 8 September. 8 September. It's
Yes.
Lordship, this is the Honorable Division Bench judgment. If it is in contravention of the provisions of law that there should be demolish, and this is a element discretion remains with the authority. Lordship. This is Falguni Mukherjee versus State of West Bengal.
আচ্ছা আরেকটা আছে
Unreported judgment.
Paragraph number. Which paragraph?
Lordship, paragraph 9. Lordship, kindly come paragraph 6. I'm sorry, Lordship, paragraph 6. Six and line, Lordship, I'm just relying upon. Now, Lordship, the Biswajit Pramanik, Lordship, which judgment I have relied, that is 8 September 2021. That's the previous judgment. It was further, the Pradhan has, again, this was passed, again, this was agitated before this Honorable High Court. Now, High Court has passed a detailed order. That is kindly come, order dated 6 April 22, judgment. 6th April, 6th April 22. That's it. Just I am reading from paragraph page 5. Now, so kindly come page 4. The question to be answered by this court as to follows: whether Pradhan was empowered to order demolition. So the questions was formulated in this judgment. Whether Pradhan was empowered to order demolition, whether Pradhan could have directed the petitioner to file an application for sanction showing a common passage, whether decision that construction was unauthorized should have been taken by Gram Panchayat and then referred to the subdivisional officer 23(5) of the Act. With regard to the first question, court is of the view that section 23 of the act makes it mandatory for any persons who wishes to erect any structure or building to obtain a previous permission in writing from the Gram Panchayat. It is clear that Gram Panchayat is the permission granting authority to allow erection of any structure or building or any addition, alteration of a structure of a building. Section 23(5) of the Act provides that when any new structure or new building, any addition or any structure or building is being or had been erected or made, as the case may be, in contravention of the provision of subsection 1, meaning thereby that such construction has been made without permission, and the permission granting authority shall refer the matter to the subdivisional officer concerned, who may, after giving the owner of such building an opportunity of being heard, make an order directing the demolition of building or a portion of the building within a specified time. The subdivisional officer, who has been empowered to effect the demolition and impose a fine as the may be specified in the state government, and thereafter recover the cost thereof from the owner as a public demand. In this case, expression shall is a mandate on the permission granting authority to refer the matter to the subdivisional officer. As such, the decision cited by Mr. Sinha in such and such shall be construed as may for public convenience and is not accepted by the court. The section 25(5) incorporated by the amendment in 2017, despite where being a provision under subsection 6 of section 23 of the Act, empowering the authority to order demolition and take steps for such demolition. The legislature of its wisdom incorporate in mandatory provision to refer such matters to the subdivisional officer before an order of demolition is passed. Such order affects the right of a property of a citizen and results in demolition of his property. Incorporation of section 6 to the provision of law, in spite of existing provision of section 23(6), is a clear indication of the intention of the legislature to provide a double safeguard before such demolition takes place. Thus, the decision of PEC Limited shall be applicable in this case. Section 23(5) and 23(6) have to be harmonious construction, and they cannot be mutually exclusive or mutually destructive. When the legislature brought in the amendment by incorporating section 23(5), despite there being a provision of demolition, upon harmonious construction of these two provisions of law which operates in the same field, the court is of the opinion that amended provision of section 23(5) shall prevail and must be followed. In the event direction by the Pradhan was contrary to the provision of such act, the law is clear. The permission granting authority has to refer the matter to the subdivisional officer, and the permission granting authority, as per the provision of section 23 of the Act, is the Gram Panchayat, not the Pradhan. The Pradhan can at the best intimate the order taken by the Gram Panchayat by a resolution to the effect that the said construction was unauthorized, will have to taken by the Gram Panchayat and then referred to the subdivisional officer. The court is not inclined to go into the factual finding of this case. Same are within the domain of the authority. Court is of the view that all the Pradhan has direct or dispose of the representation, yet the proper course of action would be that the Gram Panchayat should have taken a decision with regard to the unauthorized construction, then referred the matter to the subdivisional officer under subsection 23, subsection 5 of the said Act, and the subdivision should have proceeded in accordance with law with view to mandatory provision of section 23, subsection 5. Under such circumstances, matter is remanded back to the hearing of the Gram Panchayat, such and such and such. So, let's see, the Pradhan has already decided that this is in exercising the power as 23, subsection 5, that this is an unauthorized construction. Now, let's see, then refer to the subdivisional officer. But the subdivisional officer has entered into the factual finding, and without holding this order is bad, again remanded the matter, keeping, let's see, this order of the demolition Pradhan aside. Now, so this is my submission.
Then the subdivisional officer is to hear the owner. On which ground he will hear the owner?
Lordship, I am the complainant of this, Lordship, the unauthorized
But
construction.
they are
Let's-
not the owner.
It's a question of, not a question of revisiting. The judgment you have cited, it says that it is a old safeguard given so that no illegality is been done.
Lordship,
Suppose an order is passed, not in this case,
yes,
just for the sake of example, an order has been passed by the Pradhan for
yes,
demolition of a building
yes,
against which and there is a existing sanction plan. But
yes.
for any reason, the
Yes,
resolution
yes,
has been taken for any reason. Now it has been referred to the subdivisional officer. Will the subdivisional officer be only granting for illegal demolition of that structure or go into the fact that whether sanction plan is there or not?
Now, Lordship, on the
Because
basis of a
If you
sanction,
go through 23(6),
yes,
it does not say of the person who is complaining. It says of the person who has built the structure after hearing the owner of the building.
Yes, over here.
now, Lordship, this is first of all, this is my complaint. Lordship, the complainant has to be given, Lordship, the right of audience. Lordship, that has not given. Not only that, Lordship, now, Lordship's example, Lordship, may I say, Lordship, suppose there is a sanction plan. Now, Pradhan, by intentionally, with a somehow unknown grudge, Lordship, the passed a resolution that this is an unauthorized construction, referred to the Lordship, the concerned subdivisional officer. Subdivisional officer, the erring persons, obviously, as per the Lordship law, notice has to be served. If subdivisional officer come to the finding that there is an existence of a sanction plan, Lordship, on the face of record, the order of the Pradhan, Lordship, this is illegal. But here in this case, Lordship, this order, why I am challenging, here in this case, the erring persons who has raised this construction, Lordship, there is no finding that this structure has a sanction plan. First of all, there is no finding, no documents able to show that there is a sanction plan. Lordship, suppose the inquiry report, Lordship, the subdivisional officer has not considered the inquiry report. Inquiry report clearly, the executive officer's report clearly shows that there is a structure but without any sanction
Not
plan.
the case that he cannot get into the merits or the factual finding. He has the authority to get into that to find out whether there is legality or illegality in the order passed by the Pradhan.
Yes. Now this is the only. I
This you
am
can
on that.
say.
Lordship, I am on
That
that.
Since the Pradhan has said that there is no permission, there is illegality, he has gone into some other aspects
Yes.
without considering what has been taken in the resolution. This can be the, but
yes.
he cannot get into the merit. I think that is not the proper argument.
Now, Lordship, the factual finding of the Pradhan cannot, Lordship, the subdivisional officer.
Otherwise, the Pradhan's finding has to be sacrosanct. We accept that and pass order.
Now, Lordship,
What is the safeguard?
Pradhan finding can be interfered when there is a valid documents able to show by the erring persons.
But he
No
can get into
documents
that.
has been showed by them.
That you can argue.
Yes, this is my only subject.
Yes, Mr.
Let
Lordship, may I submit? Lordship, the dispute which has been arose is totally civil in nature. A title suit, civil case, a title suit being number 131 of 2024 has been pending. And the civil case has been filed against the Pradhan, Jikutta Gram Panchayat. Lordship, here is the High Court information slip on the same plot of land.
No, who have filed this?
Lordship, the private respondent has been filed the civil suit against the Pradhan on the same plot of land, and that has been suppressed, totally suppressed. And that matter is pending till this date.
No, কে ফাইল করেছে? Who filed this?
The private respondent filed this suit.
আমি ফাইল করেছি?
Private respondent
ও
filed
আচ্ছা। No, sir, I have not filed any.
on the same plot of land.
আমি কি পার্টি মামলা?
The two party. And Lordship, my second point is that the land is
When did
recorded.
you file the title suit?
Lordship, in the year 2024,
After the Pradhan has passed the order.
Lordship, probably I did not get the date, filing date exactly.
The point for not disclose the suit.
Where is the plaint?
Today I have communicated with the
It
client.
has
but
to be
today
seen because you say that they have suppressed.
They have
Now I have to find out in the plaint what you have suppressed. That's why I'm asking you when the order was passed by the Pradhan and subsequently to restrain the Pradhan, you file a title suit, knowing fully well that there is illegality in the order.
No, I have
No,
communicated.
no, where
with
is
my
the copy of the
client,
plaint then? Show me.
the-
And also not implicate the parties who is before this court. You have not implicated them as a party. Then let us examine what is it, what you have stated in the plaint. The topic, if you record. When did you file this suit? And when was the order passed? Order was passed on which page?
Lordship, page 62, 52. Demolition of 4th July 2022.
22. So this is after that. Because the suit is numbered as 131/2024 after 2 years.
no, after 2 years, but same plot of land. Lordship. The plot of lands are same. And Lordship, the lands are private property. Lordship, the lands are recorded in my parents' name. They did not annex the Orcha, Lordship, or what. But this is a private land. And so far, section 44 of the West Bengal Panchayat Act, Lordship, the authority, the Gram Panchayat has to, after, there may be a requirement for road, Panchayat road, constructing a Panchayat road. But the Pradhan should have to communicate this matter with the owner of the plot. But no notice till date has been received by the private respondent. This is a private land. And Lordship, when the concerned SDO passed this order, Lordship, what they have done, they have conjointly attacked my house and beaten my family members, and head injury was inflicted, Lordship, and FIR has been lodged against them. Lordship, here is the copy of the FIR.
You have filed your report.
But, not a report, but our instructions, we have instructions were there, we have handed over it.
Lordship, here is the FIR. 307 has been inflicted.
Still report has not been filed.
No, if you come up with all this, then they should be given an opportunity to reply. This is by this way, how can this be adjudicated by the court? One after the other, you are taking out from your bag and placing it before the court. Come up with an affidavit, annex all the documents, let them examine and file the reply.
Yes, sir. That can be.
Why then you have allowed Mr. Mukherjee to agitate all these points? At the first instance, you would have said that you need to file an affidavit in opposition. You are not carrying the plaint. Also, what is the averment made in the plaint? Whether it was filed after the SDO has passed the order. You want to protect your property, fine, but there has been some suppression in the plaint, as I presume. These orders passed by the Pradhan and SDO, this has not been disclosed. They have not been implicated as a party. How could they come to know?
Lordship, I shall submit an opposition.
Lordship, Lordship, may I say one thing, Lordship, as the order of the subdivisional officer is palpably contrary to the records, Lordship, let the subdivisional officer, Lordship, again revisit this issue. Kindly set aside the order. Yes, upon giving an opportunity of hearing, because prima facie the subdivisional officer observation is contrary to the records.
Ashok. Yes, Mr. Samantu, what is your submission?
My lord, my lord, two things, my lord. One, my lord, if your lordship is eager to send the matter or relegate the matter to the SDO after hearing all the party, the SDO can pass in fresh order. My lord, that is one aspect. And another aspect, if your lordship asks me to address on the merit, my lord, I can, my lord. If your lordship, up to your lordship's desire.
So this was referred after the matter was, one application was filed before the SDM. Block Development Officer thereafter indicates that as per 23(6), it has to be referred.
Yes.
Now it is a fact that he has not been notified. He was not present. Though it records that everyone has been heard,
But
But
my lord, he
at the initial stage, it records who were present.
subject to
So-
correction, my lord, they are not the party. They may not be the heard.
Hmm.
Because my lord, they made a representation to the Pradhan.
Hmm.
The Pradhan was represented. Pradhan was given hearing by the SDO.
Hmm.
That his voice has been agitated or been canvassed by through the Pradhan. Yes, ventilated and grievance through the Pradhan. Because there was a written representation and my lord,
So it will go back to him. I will ask him to serve notice to all the parties
my lord,
in their presence.
that's
to
why I-
disposed of.
that's why I
And
submitted
also,
report.
also
That
he
will
has
be a
indicated one point
that will be a shortcut.
which will be acceptable to all.
My lord.
That if the Pradhan says that there is no permission, there is illegality in the construction,
My
that has to also be gone into.
Yes.
That no, there is no illegality, there is a sanction plan. He has not gone
Let
into. What
the
he says
SDO
is,
decide all the issues.
he gets into section 44. 44 of not acquiring in accordance with law of a land where the road has been constructed.
My lord.
And the cow shed they have already broken. My cow shed.
Ashun. This repetition প্যারা করে দেবে না paragraph 1 2 3 4 করে যাবে is filed challenging sorry or setting aside and or withdrawal of the minutes dated 21st November 2023 passed by subdivisional magistrate Rampurat Birbhum. The petitioner, there are two, the petitioner contains that the petitioner number 1 is the owner of LR plot number 631 under Mouja Huincha, jail number 75 under Moireshwar 1 block under police station Mallarpur. The plots of land being plot number 641, 642 and 643 has been approved for PCC road from Palash Mondol's house to Mihir's house, comma, which is the only way to ingress and egress of the petitioner's residential house from the main Panchayat road. All adjacent landowners of LR plot number 641, 642 and 643 have left minimum open space for the purpose of ingress and egress. The private respondent, which paragraph, have undertaken unauthorized construction of a cow shed khatal without obtaining sanction plan and encroaching the PCC road. The petitioner made a representation on where is the complaint?
What's the my complaint at
My lord, page 43. Yes.
page 40?
Made a complaint before the Pradhan on 20th June 2022. Notices were, on the basis of such complaint, notices were issued to the private respondents and the resolution was passed by the Pradhan passed by the Chikida Gram Panchayat. Copy of the resolution, page number.
Also, copy of the resolution, page 58. Relevant page is 59.
Jikida Gram Panchayat. Huh? The resolution was passed by the Jikida Gram Panchayat. Only the construction undertaken by private respondent as illegal and unauthorized. Notices were issued to the private respondents for demolition of such structures on the date of resolution. What is the date of the resolution? It is
So resolution was taken on
it is 20th July, no?
20th July
20th July 2022.
2020.
Notices were issued to the private. Notices were issued to the private respondents on 22nd August 2022 for removal of such illegal structures. By dint of an order passed by Executive Magistrate Rampur Hat, the Pradhan was directed by the Block Development Officer Muireshwar 1 Development Block to suspend the removal of illegal construction over the property in question and refer the matter to the subdivisional officer concerned in terms of section 23 subsection 5. Again, given subsection 5 of section 23 of the West Bengal Panchayat Act. Pursuant thereto, the Pradhan referred the matter to the subdivisional officer Rampur Hat, Birbhum. The subdivisional officer, after considering the inquiry report, remanded the matter to the Pradhan Jikida Gram Panchayat to consider the matter afresh upon hearing all concerned. Challenging such date subdivision officer 21st November 2023. Challenging such action of the subdivisional officer Rampur at Birbhum, the petitioner has referred the writ petition. Mr. Prosenjit Mukherjee, an advocate for the petitioner, submits that the petitioners were never notified of the hearing conducted by the subdivisional officer. Top. He submits that the order impugned, in the order impugned, the subdivisional officer Birbhum has proceeded on some other aspects which are not connected and cogent to the fact in issue. The findings of the Pradhan, findings of the Chikida Gram Panchayat in its resolution of illegal unauthorized construction undertaken by the private respondents does not find place in the impugned order. There is palpable illegality in the said order. He seeks for setting aside of the illegality in the said order, impugned order. He seeks for setting aside of the impugned order with a liberty to the petitioner to place his case before the subdivisional officer. On the contrary, Mr. Swenso, learned advocate for private respondent, submits that they have filed a title suit before the civil judge, Junior Division, Second Court, Rampurhat, Birbhum, being title suit number 131 of 2024 against the Pradhan of Jikila Gram Panchayat. বানানটা দেখে নেবে না? Jikila. Wherein an order of injunction has been passed not to dispossess the plaintiff from the suit property without due process of law. No steps has been taken by the Pradhan under section 44 of the Gram Panchayat Act for constructing concrete slab for covering the open drain. He seeks for dismissal of the on which date this FIR has been lodged? He submits that over the dispute, the private respondents were attacked and there has been an FIR lodged at the instance of which private respondent is the complainant. Who is the complainant? Which one? Private respondent?
Private respondent's son is the complainant, Subhajit Mondol.
At the instance of Subhajit Mondol, son of private respondent number?
Private respondent number Mihir Mondol.
10. So Mihir is a party.
10 is not represented.
No, not Mihir. Mihir is not a party here.
Mihir not a party. Tapan Mondol, Ranjit.
Son of private respondent category. Son of one Mihir Mondol. He seeks for dismissal of the writ petition. Mr. joins the Shamunto learned advocate representing the state subpoena act. The matter may be relegated to the subdivision officer Rampur or Birbhum for placement. Admittedly, prior to issuance of a demolition notice, the Jikida Gram Panchayat, by its resolution, stated that the construction undertaken by the private respondents are illegal and unauthorized. The Pradhan issued notice for demolition on 22nd August 2022. As per section 23(2) by 5, the Pradhan has to refer the matter whenever there is contravention of provisions of section 23(1). At the first instance, the matter was not referred to the subdivisional officer, but thereafter, upon an direction by the block development officer, the matter was referred to the subdivisional officer in terms of section 23(5) of the West Bengal Panchayat Act. It is not in dispute that the petitioner has not been notified. Sorry, it is not in dispute. Although subsection 5 of section 23 provides that the owner of the building is to be heard, yet principles of natural justice yet bearing in mind the principle of natural justice, the petitioners should have been notified of such hearing. Furthermore, the impugned order records that the Gram Panchayat ought to have taken a resolution by general body meeting. The subdivisional officer failed to appreciate that the letter of reference dated 10th February 2023 clearly records that the Panchayat has passed a resolution to the effect that the construction is illegal and unauthorized. It is pertinent to note that the findings in the resolution has not been taken into consideration in the impugned order by the subdivisional officer. In light of the above, the impugned order dated 21st November 2023 passed by subdivision officer Rampurhat Birbhum is set aside. His response number?
So the subdivisional officer is
With the response number such and such is set aside. 5 is set aside. The writ petition is disposed of, directing the response number 5 subdivisional officer Rampurhat Birbhum to consider the matter afresh upon hearing the petitioner as the private respondents and all necessary parties, and also consider the resolution taken by the Jikida Gram Panchayat and pass a reasoned order in accordance with law within a period of 4 weeks from date of communication of this order. Learned advocate for the reasoned order shall be communicated to the parties, including petitioner and the private respondents, within a week thereof. With the aforesaid, learned advocate is directed to communicate for the petitioner to communicate this order to respondent number 5 for necessary compliance or connected.
So, with Lordship pleasure to record that I have no objection with regard to the fact that he has the right of audience before the STO. Because he has the right, he has no right of audience before the
Mr.
STO.
সামন্তর এখানে লিখে দিন যে the petitioner has no right of audience as per the provisions of West Bengal Panchayat Act.
Fine.
Yes.
Great.
দরকার নেই। এটা দরকার নেই যদি এফআইআর নাম্বারটা থাকে, এফআইআর এর কোনো কিছু থাকে তাহলে
Item number 11.
My lord, I am for the state, my lord. I am for the state, my lord. My lord, is may I audible, my lord?
yes, yes. Okay, proper. Okay, normal. The 3 for Bush. The liquidity of state. This one is. You are for the state.
My lord, I am for the state. He is my better half. She is my better half, my lord. As because I am ill, that's why I am to matter this in virtually, my lord.
So you have asked your better half to remain present, and you are.
Yes, yes, my lord. Actually, I am suffering from fever.
Sorry, sir. Take care. Take care. Sorry. Yes, Mr. Ghosh.
My lord, 12 petitioners are before your lordship. Now, my lord, my grievance is that, my lord, the land in question in the writ petition belongs to us. My lord, from
You
an
have served upon the
my lord, there is no private respondent. State is the only authority here.
কোনটা দিয়েছো গো 9491 এর প্রাইভেট রেসপন্স আছে মনে হয়?
No private respondents.
Okay, yes,
District magistrates are divisional officers.
yes.
My lord, we are the owner of the land. My lord, that lordship will find from page 13 to page 20. My lord, I have annexed the records. Now, my lord, here my grievance is that, my lord, though this is our land, my lord, the state authority started constructing building over that land. Now, so my lord, at page 23, lordship will find, my lord, I have sent for a RTI. My lord, I have sent a RTI questioning something that who is the owner of this land. Now, my lord, the RTI answer at first at page 24, it was bypassed to the another authority. At page 25, my lord, kindly come to page 25 for once. Now, my lord, the answer to the RTI was, my lord, would like to inform you that the plot index of above plots of Mouja, such and such jail number 75, my lord, the relevant plot is in torn condition and hence cannot be provided at this stage. In their website, my lord, other document, my lord, page
What did
13.
you intend to know about this jail number 75? What is your question?
My lord, the question lordship will find at page 23.
Where the polling plots?
Was the consent of the farmers taken at the time of land of encroachment? If yes, kindly provide me a copy of the consent letter, NOC of such and such. Was any kind of compensation given to the landowners for the aforesaid mentioned occupied lands? My lord, such and such. So, my lord, the question is the plot number I have given in that plot number, whether this encroachment by the government authority to the lands
They have been acquired or not?
that has been acquired or not. If acquired, my lord, then my lord, I will lose my right to that plots. So, my lord, the completely avoiding the question, which answer was given that the since the my lord, the index is in torn condition, so my lord, they cannot provide the my lord, the information to me.
My lord, may I submit?
Now, on the same contrary, my lord, from page 13 to 20, my lord, this is also obtained from the government website itself. My lord, this document shows we are the owner. The record of rights is in our name or my ancestors' names. Now the question is, my lord, the if Yes. Now the question if my lord this land was never my lord, the acquired by the state, it was never the state is not the owner of the land, but whether the state can construct a building over the land, like then how the sanction itself is in question. If I am the owner and state my lord comes and my lord build a building in my plot, my lord, the sanction even if given, that sanction itself is bad in law. So my lord, let them at first say who is the owner of the land.
My lord,
Second,
I have the instruction, my lord. I have the instruction with my wife. Kindly give the instruction, my lord. The instruction of PLLRO.
this is the instruction. Instruction the key, madam.
আমি বলছি ইনস্ট্রাকশনটা কি আমি বলছি my lord, kindly go through the map, the sanction plan. What is he called this sanction plan? The last page, my lord, the map. It is clearly, my lord. See, it's whose land. It is signed and sealed by the PLRO. It's an office of, my lord, the state initially. School inspector of.
Officer, what he is stating.
It's a Goalpukur inspector TI school, and it's previously, my lord, it's a government office. And as per the last page, my lord, it seems that the portion which they have occupied, it's a government property, my lord.
Inspector. If you construct the office, then the land belongs to you.
No, my lord, I am now construct the office, my lord. The last page, the sanction pen, the yellow border is, my lord. Last page, my lord, the map, the RS map. That is the sanction plan, my lord.
This is a private land.
Yes, it's a private land, my lord.
The private land, how the government has
No,
acquired.
no. My lord, it's not a private land. It's a public land, my lord. As per, my lord, kindly go through the page, the last, before the last page, joint inspection report of the different office situated in campus of BDO office, my lord. Specifically, my lord.
No, you can have offices over the land.
My lord, let it be decided by filing the
Whether the
affidavits, my lord.
required, whenever you make an at any point of time, the land has vested with the state. If it has vested with the state, then the petitioner has no case. But if it's not vested and the record of right shows that they are the owners, then the only option is to acquire the land and then make a construction.
Much obliged. Then, my lord, kindly give us some time that we have to take, my lord, final instruction whether it's belonging to, my lord, our land, or sorry, my lord, to
Then if the BLR is concerned, let the BLR also file the report. What is
yes,
their
my lord.
rights are there?
Yes, my lord. Let
As
the PLL file a report.
some such and such offices are over such and such land. That does not make you the owner of the
Yes, my lord. Let me take, my lord, file an instruction whether this land.
submit. Mr. Niladri Shekhar Ghosh, an advocate for the petitioner, submits that the petitioners are the owners of the land comprised within para 14 is the land,
Malad, which para lordship is saying, Malad? Question.
which is the specification of the land is para 3.
Malad, bole দিচ্ছি। Malad, paragraph 3.
3 থেকে খুঁজ বলবো না? The state authorities have are making construction of their office building without taking recourse to acquisition as provided under the West Bengal Panchayat Act. Our application was filed under the Right to Information Act. However, no satisfactory reply has come up from the state authorities, save and except that the page containing the details of Mouja Gachinagar jail number 75 is in torn condition. State files a report. Give a copy to him. State files a report dated report of block development officer dated 8 January 2025, which is taken on record. Para. Mr. Orindam
Mitro.
Mitro, learned advocate appearing for the state through virtual mode, submits that state offices are being constructed over the land belonging to the state. However, he seeks accommodation to produce accommodation to file report specifying and disclosing whether any acquisition of the land has been made or the land is a vested land. Let such report be filed by the state within a period of
8
Two-
weeks, my lord.
2 weeks.
Well,
And-
4 weeks, my lord. Kindly 4 weeks, my lord.
Affidavit for them, 2 weeks or 1 week for reply.
My lord, interim stay, my lord, the construction is going on.
What instant?
No other
Okay.
Lordship, I have to take a photocopy. There is only one copy that I have
Yes, my lord. There is
submitted.
one copy, my lord.
Wait,
What interim stay?
Why not?
It's
In-
pending for if you waiting for 1 year,
report will-
why you waiting for this? If you have more urgency, then you file this. This matter is for upgradation in the
To the court.
earlier. Now
Yes.
we are praying for stay.
acquisition, if you have made acquisition, yes. 3 weeks under returnable motion.
And my lord, the stay to
No, no,
construction
not-
to be
not-
stayed.
Let them come up with a report, we'll see.
My lord, if they have so much importance, they have to file the
Hey, Mr. Ghosh,
upgradation.
Grateful, Your Lordship.
check it back,
Yes, Lord.
but
I
don't forget
have
to hand over to the
importance.
court officer because I have recorded the order. Yes.
My lord, before my lord rises, my lord, the next item. Before my lord rises the next item, my lord, I'll be seeking an accommodation. My lord, there was a direction to serve a copy of the order upon
Much
the
obliged.
Jilla Parishad, my lord. The order was only uploaded yesterday night. So we could not, my lord, serve, my lord. So if this matter could be made returnable next Tuesday, my lord, in the meantime, we'll serve.
No, 11,
12. My lord, Mr. Chondicharan Dey is appearing, my lord, we'll intimate him. We'll intimate him, my lord. This order was uploaded only yesterday evening, my lord. If it could stand over till next.
Orijit Bardhan, learned advocate for the petitioner, seeks accommodation to serve upon learned advocate for
Not the advocate, my lord, upon the
Jilla-
Zira Parishad. They are not appearing.
Jilla Parishad. Please, this matter, it is 24 matter. Next week, next week, Monday.
Monday, my lord.
Top
At the top, my lord. Retain his position, my lord. I'm so grateful, my lord. So grateful, my lord.
এটা আগে দিয়ে দেবেন তো আজকে আপলোড যাতে করে দিতে পারি ওকে থ্যাংক ইউ
Lordship, I am for the applicant, Lordship. I am for the state. I am filing vacating application, Lordship, in terms of the order passed by the Honorable Justice. Lordship, kindly see page 15, Lordship. This is the order passed by the Honorable Justice Dinesh Kumar Sharma, dated 8/4/2025, Lordship. There is a tender matter of the ferryguard, Lordship. I am for the Jala Parishad. I file a application for vacating the order, Lordship. Lordship, kindly see order is started 15, 16, Lordship. Learned counsel for the petitioner submit that the government may continue with the tender process. However, the outcome may not be published. Tender was complete, Lordship, but outcome is not published, Lordship. That is a ferryguard, Lordship. Lordship, the report, I am annexed the report. This is the report, Lordship. In terms of the order, this is the report, Lordship. I am annexed the report, my vacating application, Lordship. Lordship, the petition, Lordship, petitioner is obtained the ferryguard in the financial year of 1/4/2024 to 31st March 2025, Lordship. First writ petition filed. This writ petition not to be heard. A report is filed by the annex this. That is second writ petition. In terms of second writ petition is challenging the tender notice, Lordship. Lordship, enter fact is clear, Lordship, page 19 report, Lordship. A report as well as the brief of connection with the, sorry, page 19, Lordship. There is a vacating application. Otherwise, Lordship, report in form of ABDB. The report is it was. Is
The allegations made by the petitioner, my lord, it is absolutely false.
Who is for the petitioner?
petitioner
Petitioner is not appearing because he is using that ferry service.
without revenue, Lordship, till now, Lordship.
If the interim order is not vacated, my lord, it continues. He is still continuing without the tender process being implemented, the new tender process.
Its period is expired 31st March 2025, Lordship. Till now is operating. Auction is held on, Lordship.
Will be dismissed for default. Ashwin. None appears on behalf. This matter is appearing under the heading to be mentioned. None appears on behalf of the petitioner, nor any accommodation has been sought for. it appears that the petitioner on the last occasion, that is 13th August 2025, also failed to appear despite service of notice. In view of the above, the writ petition being number WPA 75313 of 2021 dismissed for default. The
All the interim orders
interim
will
orders vacated, connected applications are disposed of. Urgent photostat certified copy applied for.
That's all interim order is certified. That's 1 minute, Lordship. He is operating physical till now, Lordship. During that time, 4.5 months, Lordship. Recovery of the revenue, Lordship.
We will get into the merit of this application.
Malad, two, it was disposed of on 11th. One correction.
Oh, yes.
The ordering
That
portion,
matter is
Malad, the
submitted
page 2.
to be mentioned. What is the correction?
Malad, correction is Malad on the date 8th November 2011. It will be Malad 2007. Page 2, ordering portion on the page 2.
It will be 7.
It
In
will be
any other
7.
portion, this 8th
Malad,
this 8th November 2011 is appearing in any part of the order, any other part of the order?
no, Malad.
This
Part
is-
of the order 2007, it was recorded. 2007.
8th November 2007. In page 4, it is correct.
My only page for it.
This matter is appearing under the heading to be mentioned. Para 2, inadvertent typographical error has crept into
Naam di do.
paragraph number 4 at page 2 of order dated 11th August 2025. In 1, 2, 3, 4th line, mentioning the date as 8th November 2011 instead of 8th November 2007. The date in the aforesaid order in para 4 at page 2, 4th line, be read as 8th November 2007 instead of 8th November 2011.
Remaining
The
part
other
is
portions of the orders, the order is modified to the above extent. The other portions of the order shall remain allowed. This order shall form part of order dated 11th August 2025.
good.
Next, 14.
Number 9.
9.
Record the spelling regarding spelling of the minor exponent number 2 and 3. Minor kindly add
My lord, this was disposed of.
disposed of matter. By your lordship, my lord, only amendment of the first title regarding name. At first, my lord, kindly see page 9 of my application. Page 9. That is the amended page. Here, my lord, your lordship will find that the second person, my lord, Shantanu Gorai, the spelling has been written as SHANTANU. And in the memorandum, my lord, SAN has been recorded. SHAN. And ordering portion, my lord, kindly see. Ordering portion, my lord, page 19. Page 19, second paragraph, your lordship will find.
Where is the
It is
measure?
the order of the tribunal given. Ordering portion, page 19.
You have written Shantanu, SANTANU.
Yeah, SNTNA. It will be Malad SHANTNA. Malad, this is the appeal of insurance company. And Otonu name, Malad spelling will be Malad ATONU instead of ATANU. Malad, my prayer portion is there, Malad. Page 6. Page 6, Malad. Prayer 1 and 3.
Okay. Where is the document?
Document, my lord, yes, my lord, Aadhaar card has been annexed here. My lord, 31, page 31 and 32.
Otonu.
My lord, 30 and 31. Page 30 and 31. SHANTANU.
3 of 2025. এই ওটাই আগেরটা না রিপোর্ট হ্যাঁ ফাইল বাই দি আগে যেটা অর্ডার হলো ডিসমিস ফর ডিফল্ট মানে এটা রিপোর্টটা নিয়ে নেবে
Otherwise, my lord, check will not be
নোট করে
entered.
নেবে না রিপোর্ট ফাইল বাই দি জেলা পরিষদ ইজ টেকেন অফ রিপোর্ট and 3 of 2025 this is an application for amendment of first title of memorandum of appeal as well as cross objection. Mr. Jayanto Mondol, learned advocate for respondent claimants, submits that the names of respondent number 2 and respondent number 2 and respondent number 3 should be corrected as Shantanu, Shantanu Godai, it is inverted commas, and Atonu Godai, Atonu Godai, in place of Shantanu, Santanu Godai, and Atonu. What is the spelling in memorandum of appeal?
ATANU.
Atanu Godai. He seeks for necessary order for amendment of the first title of memorandum of appeal. Learned advocate for Appellate Insurance Company does not raise any objection. Considering the amendments made in the application as well as the documents annexed to the application, let the names of respondent number 2 be amended as Shantanu, SHA, এটা প্যারা 6 এ আছে, and respondent number 3 be as Atonu Godai. Department is directed to carry out such amendment. Application being canon 3 of 2025 statute.
Otherwise, one of the NCAS will be one of difficulty.
Item 13, my lord. I beg to appear on behalf of.
My lord, I am appearing for the state respondent.
This is the first affidavit of service after filing the writ application. And this is the second one. During the pendency of the writ application, I am constrained to file a supplementary affidavit. I served all the supplementary affidavit along with the writ petitions.
Who was the private respondents?
The last occasion, the private respondent has refused to accept the same, my lord, that my last affidavit, my lord, that refused.
Who now delivered. And respondent number 6. Four one. Delivered. Your turn.
I am for the state respondent. 1 to 4.
Yes.
IC BDO BLRO.
Now, my lord, I was also submitting my supplementary affidavit. That is very important to adjudicate the entire matter. My lord, the subject matter is that the petition that the private respondent number 7, in absence of any sanctioned building plan or without any prior consent from the concerned panchayat authority, the panchayat means the respondent number 5 herein is the panchayat and respondent number 6 is the panchayat pradhan. They have started a construction upon the land as I mentioned in paragraph 4 in my writ petitions. And one more point that must be taken into the consideration: the land whereupon the alleged construction is constructed by the private respondent, it's actually a patta land, my lord. And my lord, from the annexure P1, it reveals the patta was allotted in someone else. It starts from the, my lord, the page 17, 18, 19 and 20. The Sopon Sardar is the original patta holder on whose land the construction has been made. And my lord, immediately, and such a construction, it is otherwise restricted my ingress and ingress to my own properties, my lord. And immediately after they have started the construction, my lord, I raised a representation to the concerned panchayat, that is, my lord, page 21 in my writ petitions.
Yes.
Thereafter, my lord, kindly have a glance at page 22, the annexure P2. I again made a representation to the Pradhan of the concerned Gram Panchayat. But in spite of knocking the door of the Pradhan, they did not heed to my request, my lord. As a result, whereof I made an application under the Right to Information Act in order to ascertain the true facts of the case. They remain silent over the issues. Thereafter, my lord, challenging the inaction as well as the non-action on the part of the Panchayat Pradhan and the Panchayat, I preferred the instant writ application before your lordship.
Yes.
And my lord, during the pendency of these writ applications, my lord, initially after filing the, it is an admitted position, my lord, initially after filing the writ petition, the construction was stopped. But due to the pendency, they again started the construction, my lord. And my lord, whenever, and my lord, one another point, my lord, kindly.
Fine, my lord, the Pradhan is the answering respondent, my lord. I am not representing the Pradhan. My learned friend has made representation before the Pradhan. There was a dispute between the private respondent and the petitioner, my lord. Police has already taken action, my lord. 3 NCR case has been registered.
Give the report.
My lord, I have that.
And my lord, in my writ petition, my lord, in my supplementary affidavit, my lord,
report, my lord.
My lord, kindly
From IC.
kindly have a glance at page 11 and 12, my lord, wherein, my lord, one of the member of the Gram Panchayat, where the property, the alleged construction is carried on by the by the private respondent. The concerned member, she has reported the entire incident to the police, because whenever I restrained them, they tried to threaten me. They threatened me with the dire consequences, my lord. This is the scenario.
Affidavits of service filed on behalf of the petition is taken on record. By the present petition, the petitioner seeks direction upon the respondent authorities, particularly respondent number 5 and 6, the demolition proceedings against the illegal construction undertaken by private respondent number 7. Over which land? Which land this illegal construction has been undertaken? Over Dag number 992, jail number 24, Puja under police station Kalna, district Purbo Bardhaman. The petitioner contains that the private respondent number 7 has undertaken illegal construction without conversion of the land, which is classified as Tali, stock, and without obtaining any building sanction plan. The said construction has caused obstruction to the ingress and egress of the petitioner. The petitioner made a representation before the, which one is the last one? P2. What is the date of P2? What is the date of annexure P2?
Date of the annexure
The made,
is my lord
20th February 2024.
24.
Stop. However, no steps has been taken. Hence, this writ petition. Mr. Swansol, learned advocate for the petitioner, submits that the entire construction undertaken by the private respondent number 7 is illegal, since the land is classified as Sally and patta has been issued in favor of one. What is his name? Patta holder? Chopon Sardar.
But the Sopon Sardar. Well, that is annexure P20. The name of the
He seeks that
patta holder is mentioned in the
specific direction be issued upon respond number
page 20, my lord.
5 and 6 to consider the representation of the petitioner. Learned advocate for the state, Mr. Swenson, learned advocate for the state, submits that over the dispute, criminal cases has been initiated. Criminal case has been initiated. Under sections 107/116 slash 116 within bracket C of the CRPC. Upon consider submissions advanced by the despite service none appears on behalf of the Pradhan, respond number 6 and private respond number 7. Upon hearing the learned advocates for the appealing parties, the respondent number 6 is directed to take to consider and dispose of the representation of the petitioner by adopting the following procedures. Srimani Babu Kachir points গুলো নিয়ে নেবেন। Points গুলো বলা আছে। Within 2 months, the entire process has to be from the date of communication of the order. ওখানে points গুলো বলা আছে within 2 months. Disposed of. হ্যাঁ? তাহলে এর কাজে আছে। আর কি আছে বলো?
Since the state has not used any affidavit, all the allegation is denied, my lord. Let it be recorded.
Completed within a period from date of communication. Since no affidavit has been called for, it is made clear that this court has not gone into the merits of.
I'm grateful.
Devnath Babu.
Milord, I am for the petitioner, Milord.
I'm for the private.
My lord, I am appearing on behalf of the state, my lord.
Milord, here the said private respondent has started a illegal construction and encroaching my land, my pond and the common drain. Milord, I have annexed the photograph of the said construction in page number 19. They have extended their structure over our land, encroaching our pond and the common drain, Milord. And in page number 33, Milord, we made the written representation 9th April to 2024 to the Panchayat Pradhan about the said illegal and unauthorized construction. Milord, in para 2 of the said application, they are building house illegally and blocking the drains. On drains means the public use and the provision of they are filling our pond. That is our pond, encroaching our pond without the permission, and they are making the said construction without any plan, Milord. We have also made written representation to the OC Sakrail Police Station in page number 37, stating all the fact. And the BL or RO has
Yes.
made the
State-
inspection.
State, you are for the state?
No, my lord, I'm for the private respondent.
For the state, my lord. Basically, my lord, Jila Parishad as well as the Gram Panchayat is the answering or respondent, my lord.
The answering respondent, because what happened, my lord, here, my lord, I inherited the property from my.
No, my lord. Property has not been inherited.
Let him
He
submit,
will-
my lord, then, my lord,
No, my lord.
He will raise one
I
issue,
am-
he will again reply.
No, no, my lord.
My lord, my father purchased the property from the erstwhile owner. My lord, after the death of my father, I inherited the property. Now, my lord, the total 5 cutters of land. Out of 5 cutter, my lord, the erstwhile owner, my lord, transferred, my lord, keeping aside 1 cutter and odd to the 3 my lord, individual persons. Now, my lord, the property was transferred, my lord, in a demarcated mode, and my lord, my father possessing the specific demarcated portion. Now, my lord, what happened, my lord, after the death of my father, I converted the land, and my lord, I obtained a sanction from the Howrah Jila Parishad. Now, my dispute cropped up when my lord, I entered into an agreement for sale with the erstwhile owner for remaining land. If your lordship consider the representation, my lord find that it is his case that there are encroachment, there are my lord, keeping aside some of the materials over a vacant land. These are the my lord, allegations made in the representation. Now, dispute cropped up when I entered into an agreement for sale and my lord, obtained possession from the erstwhile owner in respect of the vacant land. Now, my lord, when the such my lord, resistance, my lord, beyond our control, my lord, we move a civil court, my lord, obtain an order of injunction. A civil suit is pending between the petitioner and my lord, the private respondent. And my lord, they are also contesting the suit. In the plaint of the said civil suit, I find, my lord, that the property converted on, my lord, 28th of February 2020, and my lord, the sanction plan obtained on 30th of January 2023. Now, so far as, my lord, the allegation of encroachment and, my lord, encroachment is concerned, my lord, it is absolutely the domain of the civil court. So far as, my lord, the allegation that I am raising construction on a pond, that is also my lord, the domain of the BL and LRO under 4C of the Land Reforms Act. Only to the extent that whether I am raising the construction unauthorizedly without any proper sanction plan or not. That is, my lord, the subject matter of this writ petition. Now, my lord, if the Jila Parishad come, my lord, I also, my lord, bring, my lord, the sanction plan as well as my conversion certificate. If the Jila Parishad come and they say that it is their sanction plan, they have the petitioner have no case.
Okay.
My lord, as per the information I got from the BLL and LRO office, land is converted. There is conversion plan, my lord.
You have the conversion certificate.
My lord, presently I don't have the, but my lord can consider, my lord, my plaint where I have given the specific details of the conversion as well as, my lord, the sanction plan number.
You have served upon the Jila Parishad.
Yes, my lord.
Where is that?
My lord, I have filed the affidavit of service to previously, my lord.
And my lord, after obtaining, my lord, the order of injunction in compliance of Order 39 Rule 3, my lord, I have served, my lord, the copy of
Yes,
the
my lord.
conversion certificate, sanction plan, along with the plaint to the writ petitioner. And this is the order of injunction what I obtained from the, my lord, the civil court.
My lord, the injunction was obtained to other person.
Where is your affidavit?
Other person?
Yes, my lord. It is the copy of my affidavit, my lord.
Ramesh Mondal. My lord, the defendant number 3 is the writ petitioner. Kindly see, my lord.
Yes, my lord. I am one of the writ petitioner, but the
We were making that
allegation
injunction
was
with
made
the other person.
to other person.
Is to poison plenty and to dependent in disgrace property and where is the affidavit of service?
Yes, my lord. I have filed it.
It is not in the record.
Yes,
The
my lord.
order does not record so that you have
My lord,
filed.
it is the copy of the affidavit of service.
কি ব্যাপার এই বলছে ফাইল করেছে এটা তো অর্ডার শিটের কোথাও নেই এফিডেভিট অফ সার্ভিস প্রাইভেট রেভেন্যু এসে গেছে তো
এই জিনিসটা যখন ওরা করে দেয় করে দিবি তো তুই তো করে দিবি এটা কত নম্বর পেজ তো বুঝতে পারছি না।
Learned advocate for the petitioner submits that the private respondents have undertaken unauthorized construction over the which plot?
Plot number 239, man.
Yes.
239 of Khatiyar number 494.
No, no, my lord. 150.
1508.
Yes, my lord.
Khatiyar number 1508. Mouja
Mouja Jorhat.
Mouja Jorhat.
Mouja Kamranga, my lord.
Jorhat. Under Jorhat.
Under Jorhat Gram Panchayat. This is the Mouja Kamranga.
Nowhere you have stated.
But from the record of right, I am stating, my lord.
Page number
Mouja Kamranga.
14, my lord.
Kamranga, Mouja Kamranga.
Yes, my lord.
Under Jorhat Gram Panchayat.
Under Jorhat Gram Panchayat. By such construction, the private respondents have encroached illegally into the land of the petitioner. The petitioner made a representation before the Pradhan. On which date?
On
9th
my lord, on 9th April 2024.
However,
my lord. And
however, no steps has been
My
taken.
lord, only my lord, sorry for my lord interrupting, my lord. On 9th April representation, my lord find that there is an allegation of encroachment and unauthorized construction. If your lordship kindly consider the representation to the Pradhan dated 9th of July. Here, my lord,
So what is his prayer then? He is asking for which of the
here, my lord, there is no allegation of unauthorized construction.
yes, my lord.
Yes.
unauthorized building he has stated.
Mhm.
Now, my lord, kindly turn to page 31.
30.
30, my lord.
Yes.
This is also a representation to the Pradhan in respect of the same plot. Here, my lord, the allegation is that I am blocking the road so that he cannot, my lord, cross his land. Secondly, my lord, I
want to say that there is variance in the
yes
representation. Several representations were several representations were made before the local Gram Panchayat, however, no steps have been taken. Hence, on the contrary, there is senior advocate appearing for private respondent number 7. Submit that the petition, private respondent number 7 has inherited the property from his predecessor in namely his father. Purchaser of the land from the erstwhile who father বলেছে তো? Who was the purchaser of the land from the erstwhile landowner. After such purchase, the conversion of the land has also been made. What was the earlier classification of land? Bagan. From Bagan.
The conversion date is
On
28th of February 2020, my lord.
20.
Yes, my lord, 2020.
20th February 20.
28th
28th February 28th February 2020. Thereafter, the construction has been undertaken on the basis of a sanctioned building plan,
Dated 30th January 2023.
30th January 2023. Therefore, there is no such illegality in the work of construction undertaken by the private respondents. He seeks to file. You file your affidavit in opposition, annexing all the documents. Acha. He also submits that the private respondent has filed a title suit, civil suit, being title suit number 597 of 2024, wherein an order of injunction has been passed restraining the principal defendants from interfering with the peaceful possession of the plaintiff and pro forma defendant in respect of the scheduled property. He seeks to file affidavit in opposition. Learned advocate for the state, Mr. Bimal Kumar Shahi, learned advocate for the state, submits that the private respondent has got obtained conversion of the land in question. Let such affidavit in opposition, 2 weeks, 1 week for reply. Same way, report in the form of affidavit be filed by the state within 2 weeks and 1 week to file exception. A learned advocate for the petition is directed to intimate Howrah Jila Parishad. Respond number?
4, my lord.
4. And file affidavit of service on the returnable date.
Take back the copy.
Grateful, my lord.
Copy gulo diye din. Return 3 weeks for return. 3 weeks. 3 weeks. Yes, thank you. E.
Thank you. Manager.
Effect service. That is served upon the final affidavit of service.
Follow served, my lord. So for the private respondent is concerned, my lord, the article tracking report was not available at the time. Thereafter, my lord, the envelope was returned. Your lordship kindly, and with the intimation, my lord, that the I need not to make any trouble, your lordship. Your lordship will aware.
So effect service on all the respondents.
All the respondents,
So
including private respondents.
who are all the respondents? State is there.
Is the lordship.
I'm attending for the state.
Law. Pradhan.
Pradhan also be.
Where is service upon Pradhan?
देखिए respondent number 4.
Where is the service upon Pradhan?
Lordship, just a second. Lord, I have no allegation against the Pradhan.
The court directed to serve upon all the respondents.
Where? My lord, page 7, if your lordship, in the affidavit service, lordship, it has been sent by mail. Page 7. Lordship. My lord, my
May I submit report of
Wait.
lord, very small case, if your lordship kindly allow me, just 1 minute, then matter will be clear. My lord, after
affidavit to the কোথায় আছে প্রধানের সার্ভিস?
Hey. ঠিক আমারই বকা খাওয়া করছে আমারই ভুল করেছি লর্ডশিপ কারেক্ট আই ওয়াজ রং
Okay.
Lordship. My lord, the grievance of the petitioner that the local authority, my lord, did not cooperating the petitioners even after getting the land, my lord, for erecting for his own residential purpose after getting a sanction plan from the my lord, the Gram Panchayat. If your lordship take trouble to the, my lord, I am without wasting lordship valuable time, only 1 minute, my lord, that the page 26 to 46, these are my give deeds, relevant deeds in favor of the petitioners. And page 46 to 54 are the record of rights. I have mutated my name. Two petitioner herein, both their names feature in the record of rights. There I have converted my name, page 55, Anbastu to Udbastu to Bastu.
Which is the plot number?
Plot number 1037. 1030. Sorry, stand corrected, Lordship. नहीं.
So 1030, where the record of rights? 1086. Which page number? 10.
Page 47 in my name. Kuntal Chawli, petition number 1. Your lordship got it? And followed by, if lordship take trouble to the, I'm coming, lordship.
Which is the subject land in the written? 1030 is not the subject land.
No, my lord, only so far my land is concerned, I am not disturbing anywhere. Only I got sanction from the municipal Panchayat authority in respect of 1037 after getting conversion. And if your lordship take trouble to the page 66, this is sanction plan.
Where is the record of rights in relation 1037?
1037, just your lordship. তো জিজ্ঞেস করো তো, এটা তো বাঁধেনি মনে হচ্ছে। Lord, stand corrected.
1390.
Lord, it would be 1390. I'm making mistake, my lord, not 1037. It is a 1390. Lordship. Your lordship correct.
1390.
Lordship. And 55, my lord. Your lordship, kindly turn the page 55. This corroborating the facts. Your lordship got it? The conversion. Report in respect of the Mauja concern and in respect of the land.
2.62.
Thereafter followed by application submitted before the Gram Panchayat for obtaining a sanction plan. My lord, page 66. Initially, my lord, 66 for the petition number 1 and 60 is the petition number 2. Your Lordship got it? Now, my lord, when I have started
Is the name of petition number 2?
petition number 2, Kuntal. Kaushik and Kuntal, two brothers. My lord, when I have started the constructions, my lord, with the aids of the some officials of the panchayat, and also the private respondent created a nuisance for, my lord, disturbing the works of the petitioners somehow, and that created trouble to the petitioners. And my lord, being officer of the court, I cannot mislead that, my lord, one injunction has been prayed for before the court below. My lord, as there is no judges in the civil court, no relief was and no injunction was there. I have mentioned in my petition.
What is the where is the conversion of Kaushik Chowli?
Yes, Lordship. Correct, Lordship. Your Lordship. Kindly come to the
Kaushik, yes.
Yes, yes.
57.
Your Lordship got it. Page 73. Ye Kuntal and the
Area is
Kaushik is the
2.2.
57. So only I am seeking
The record of rights of
both the Kuntal, Lordship.
The Kuntal is there.
Lordship.
1390.
Kaushik. Kaushik. Your Lordship.
1390.
Lordship. My lord, kindly come to the page, start from 51 and it is running page 52. Kaushik Chowli.
Kaushik Chowli. 1390.
Your Lordship got it? Page 52. First name, Kaushik Chowli. So for the land ownership, LR record, conversion, sanction plan, there is no dispute, Lordship. Unnecessary without having any right title interest with the property, my lord. They create a nuisance with the help of some miscreants. For that reason, my lord, the panchayat authority advise you approach the police authority. They will assist you. Well, I under compelling circumstance, made a prayer before the authority at page 144. I have lodged, page 77.
No, what is the prayer now in this?
Only to, my lord, just allow the petitioner to complete the construction project in terms of the sanction plan, and also restraining the, my lord, private respondent not to create a nuisance in respect of the concept. Prayer B. These are the two humble prayer before Lordship. If your Lordship take trouble to the prayer portion of the petition, if your Lordship, prayer A, to allow the petitioner to continue the construction work on the basis of the sanction plan. And B, well, restraining the private respondents not to create any obstruction in respect of the. Well, these are two.
These are the prayers made in the suit also.
No, suit restraining the private respondent only.
What is the order passed?
Well, as there is no judges, being officer of the court, I cannot mislead. In Amta civil court, there is no judge at present moment.
Somebody is charged of this court?
Lord,
already prosecution has started. 107 prosecution has started. Manda police report, manda.
But then you did not file any application for under order 39?
Lord, so for this part is concerned, my lord, as there is no judges, my lord, I cannot update being officer of the court. What I know, my lord, I can suppress before law, submit
Find
before.
out what is the order passed in this civil suit.
At the present moment, there is no injunction, lordship. Or for your lordship satisfaction, if your lordship desire to, in that event, your lordship kindly allow me for 7 days time, I can get the information and provide before lordship.
আমাদের সোমবার দিন কি আছে গো? 23 কিছু তো আছে তো, তারপরে 24 মেরে ধরবে, 25 তারিখে রেখে।
And so far the police report is concerned, I did not make any comments. Your lordships know 107 is what and what is the consequence of that. So far my part is concerned that I am erecting my dwelling house.
Prayers, your prayers, it is precisely of the civil code to direct. Read code.
Only I am to, my lord, erect my building in my own land.
File a civil suit. But you say that the court is vacant, but somebody is in charge of that court.
Well, I can update
So far
you.
as the ad interim is concerned, the charge court can very well take
Your
it.
lordship apparently correct, because your lordship
Prayer
vast
of
experience
learned
with,
advocate for
with
the
regard to
petitioner.
that issues.
Please this matter on affidavit of service filed on behalf of the petitioner is taken on record. State files the report furnished by officer in charge Udayanarayanpur Police Station dated 26th November 2024, which is taken on record on the prayer of learned advocate for the petitioner. As a learned advocate for the petitioner submit that a civil suit is, what is the number of that suit?
My lord, I have.
A civil suit
Yes, yes.
being titled suit number
My lord, না বলা যায় না, একদম কোনো সাপ্রেশন থাকলে চলবে না, এটাই তো লর্ডশিপ। সিভিল সুট 116 of 2023.
116 of 2023 has been filed by the petitioner. However, he seeks accommodation to apprise the court regarding the orders passed in the suit. List this matter on 25th.
Monday 25th. I'm not keeping in the same position, otherwise the matter
After 23 matters, this 24 will be taken up. There are few matters of the year 2023, there are 24 matters.
25th. So kind of lordship.
My lord, there was a direction to serve upon the respondents and to file a fresh affidavit along with the track consignment. But due to technical issues, we could not obtain the track report yet. Kindly give accommodation.
Where is the document?
My lord,
Both the directions were given. If you cannot obtain the track consignment, you will obtain a document from the postal authority showing service.
my lord, I have no further.
Steps have you taken before the postal authority?
My lord, I have no further instruction. Mr. Amitabh Ghosh is leading in this matter.
Who?
Mr. Amitabh Ghosh.
Every week this is coming up and you have not taken any steps before the postal authority. Have you? No.
My lord, I have no.
Have you taken steps before the postal authority?
I have no knowledge, my lord. I have no instructions.
Learned advocate for the petitioner submit that we could not obtain the document from the postal authority certifying service upon the respondents. Seeks accommodation. In প্রত্যেক সপ্তাহে আসছে। কত দিন? Second September.
Grateful, my lord.
As for the state, I'm for the petitioner.
And for the private one, 9 only. Only 9.
Earlier, there was a direction, my lord, to serve upon the private respondents. I have served. And here is the affidavit of service.
8 to 14.
8 to 14. I have served. My senior learned friend is appearing on only on behalf of 9.
9.
Only on behalf of 9, man.
Filing a police report,
My lord,
but the main contesting respondent would be the Pradhan. There's some unauthorized construction.
Pradhan has been served.
Village road. So far as Ram administration rule is concerned, the Pradhan is the competent authority to demolish.
my lord.
So unless they appear before your lordship, comes to be done.
No, I've served the Pradhan, my lord. The
You might
Pradhan.
have served, but who is the answering respondent?
Pradhan is already, my lord, served.
Affidavit of service filed on behalf of the petitioner is taken on record.
My lord, the matter relates to my lord.
The notice has been sent to private respondent 8 to 14. 8 to 14. However,
ডিরেকশন থাকে
হ্যাঁ এবার
no track
direction report is annexed to the affidavit of service. Learned advocate for the petitioner is directed to obtain a document from the postal authority certifying service upon respondent 8 to 14. 9 is who is 9?
9 is my lord Motilal Haldar, private respondent.
8 to 14 না করে
Practically, there is no new construction, nothing of the sort.
Let me place my case first.
No new construction for more than
matter. Get a document from the postal authority showing service. State files report which is taken on record. Report furnished by IC Kagdeep PS dated 18th March 2024.
May I submit my lord? My lord, the matter
Well, I am submitting the police report in earlier occasion below.
Earlier occasion? Which matter?
In earlier, in connected case, my police report is there in respect of possession and old possession and such a helmet.
my learned senior friend is not allowing me to place my case, my lord. Instead of that, my lord, he is
my lord is
submitting.
asking you, what is that
আমাকে
police
একটু
report? What is that police report? That's why.
26th.
26.
And my lord, direction is my lord.
You file a document of the postal authority showing service upon 8, 10 to 14.
কত হলো?
26.
26 এ 24 থাকবে তো? 26 এ 24 থাকবে না?
18, my lord, I am appearing for the petition. My lord, ABD service intimate. My lord, I sub all as well as my lord intimation of upgradation. I sub. My lord, here I am challenging the order passed by the Pradhan, page 100.
Pradhan. Private report. Pradhan.
Page 100 is the order passed by the Pradhan. My lord, that is order passed on 22nd February 2024. My lord,
Yes. Page 100.
page 100. My lord, impugned order, which I challenge by way of writ petition before your lordship.
My lord, the dispute about the
My
nature
lord,
of the
first I placed my case, then my lord, my learned friend submitting as they want. My lord, this order has been passed. If your lordship kindly see second para. এত দ্বারা জ্ঞাত করা যাইতেছে যে ইংরেজি 12/12/2023 বিকাল 3টে ঘটনায় শুনানি প্রথম পক্ষের স্বীকারোক্তি প্রমাণিত হয় যে নির্মল দে অত্র পঞ্চায়েত ইংরেজি 13/1/2024 তারিখে আপত্তির আবেদন জানানোর পূর্বেই দ্বিতীয় পক্ষের ত্রিতলের সিঁড়ি সহ নির্মাণ হইয়াছে। So my lord, before allegation made, construction completed.
long before.
দ্বিতীয় সেকেন্ড উক্ত 13/1/2024 তারিখে নির্মাণ কার্য বন্ধ রাখার নোটিশ জারি হইতে স্থগিতাদেশ বহাল আছে। So my lord, it is specifically stated that construction is going on at that time as per the complaint made by the petitioner, then stop work notice has been issued. So construction is going on at that time. বহাল আছে এবং থাকিবে। my lord, থার্ড সরকার কর্তৃক নির্ধারিত আইন অনুযায়ী ঊর্ধ্বতন কর্তৃপক্ষের নিকট নির্মাণ কার্যের অনুমোদন প্রাপ্ত হইয়া অত্র পঞ্চায়েতে সঠিক প্রমাণাদির কাগজপত্রাদি জমা হইবার পর নির্মাণ কার্যের পুনরাদেশ আলোচনায় স্থিরীকৃত হইবে। So my lord, the Pradhan is waiting for sanction plan coming from the respondent number 8 After that, further hearing will be initiated, because here specifically stated that no sanction plan is there. So I boleni. So for that reason, the প্রধান specifically stated, সরকার কর্তৃক নির্ধারিত আইন অনুযায়ী ঊর্ধ্বতন কর্তৃপক্ষের নিকট নির্মাণ কার্যের অনুমোদন প্রাপ্ত হইয়া অত্র পঞ্চায়েতে সঠিক প্রমাণীদের কাগজপত্রাদি জমা হইবার পর, মানে that is not deposited at the time of hearing by the respondent number 8. No sanction plan has been shown before the Pradhan. For that reason, Pradhan submitted that after depositing the sanction plan from the respondent number 8, then hearing will be continued after that. So Pradhan will wait for depositing the sanction plan by the respondent number 8. So here specifically statement is there that no sanction plan is there, and construction is going on that time when allegation is made, and the second floor of the partly second floor building and northeast corner from ground floor to second floor is illegal. And my lord,
that did not
then
reflect in the order, my lord.
my lord, page 55, my first complaint before the authority concerned, when allegation made first time before the Pradhan for unauthorized construction, page 55. This is the first complaint. This is made on, if your lordship kindly see the date, 13/1/2023, page 55. My lord, specific allegation, if your lordship kindly see for a moment. আমি নিম্ন স্বাক্ষরকারী শ্রী নির্মল দে, পিতা সাচেন সাচ, কামারপুকুর হরিসভা গ্রামের স্থায়ী বাসিন্দা। আমিও আমার ভাই শ্রী মিন্টু দে বর্তমানে কলকাতার মহেশতলার নিবাসী, উভয়ের নামে 12-16 দাগের একটি দ্বিতল বাড়ি আছে, যাহার মধ্যে আমরা বসবাস করি। আমার বাড়ির পাশে দক্ষিণ দিকে নিম্ন তপশিলিভুক্ত সম্পত্তিতে জনৈকা শিলানন্দী স্বামী অশোক নন্দী মহাশয়ের একটি দ্বিতল বাড়ি আছে, যাহার উত্তর পূর্ব কোণে একটি টিউবওয়েল সমেত কলতলা ছিল, সেটি হঠাৎ করে তুলে দিয়ে ওই উত্তর পূর্ব কোণে একটি অবৈধ অ্যাডিশনাল কনস্ট্রাকশন, যাহা 3 তল অবধি করেছে, কোনো আইন মোতাবেক ছাড় না দিয়ে, গ্রাম পঞ্চায়েতের বা অথরিটির কোনো পারমিশন না নিয়ে, ইহাতে আমাদের বাড়ির সম্পূর্ণ আলু বাতাস বন্ধ হয়ে গেছে। বহুবার ওনাদের বারণ করা সত্ত্বেও কাজ হয়নি, অবৈধ নির্মাণ জোরপূর্বক। দিস ইজ দ্য ফার্স্ট রিটেন কমপ্লেন মেড বাই দ্য রিট পিটিশনার বিফোর দ্য অথরিটি কনসার্ন। And if your lordship kindly say for a moment the page, the permission which granted, page 52. Page 52 is the permission. My lord, permission given in the 2 residential house, that is one regarding Chintarani De and another regarding Sheila Rani Nundi, that is respondent number 9 hearing, page 52. উপরোক্ত বিষয় সাচেন স্যার, উপরোক্ত আবেদন মূলে আপনাদিগকে প্রস্তাবিত জনিত কেবলমাত্র বাড়ি বাসা প্রস্তুতি করার জন্য অনুমতি প্রদান করা হইতেছে। এক্ষেত্রে উল্লেখ থাকে যে আপনারা বসত বাড়ি ভিন্ন অন্য কোনো রকম ভাবে প্রস্তাবিত জমি রূপান্তরিত করত ব্যবহার করলে তাহা সম্পূর্ণ রূপে আইন ভঙ্গ করা রূপে গণ্য হইবে এবং আইনত বিধান অনুযায়ী শাস্তি গ্রহণে বাধ্য থাকিবেন। This is the permission given by the Pradhan, that is in the year 86, and the written complaint made, several written complaint has been made, and one writ application has been filed. If your lordship kindly see for a moment, page 81. The first writ application which has been filed before these honorable High Court and disposed of with some direction has been given by these honorable High Court, page 82, second para. Page 82, second para, the writ application has been disposed of. The observation made by these honorable High Court is, in the event the aforesaid respondent is of the considered opinion that the construction has been made either in violation of the plan sanctioned or devoid the sanction plan, then necessary steps shall be taken to deal with such unauthorized construction in accordance with law. This specific direction has been given by this Honorable High Court. The concerned Pradhan did not turn up, then contempt notice has been sent, page 84. After sending the contempt notice, the concerned Pradhan turn up. And if your lordship kindly see for a moment, the page 88, the notice issued by the Pradhan, my lord, my allegation against respondent number 9 to unauthorized construction, they sent to me a notice, and kindly see for a moment page 88, what the Pradhan sought for. এত দ্বারা জ্ঞাত করা যাইতেছে যে মৌজা হরিসভা জেল নাম্বার 84 দাগ 12-16 আপনাদের একতল বসবাসের বাড়িটি অনুমোদন সহ সঠিক প্রমাণাদি কাগজপত্র লইয়া আগামী 7 তারিখে বিকেল 3 ঘটিকায় গ্রাম পঞ্চায়েত কার্যালয়ে হাজির থাকিবার জন্য জানানো হইতেছে।
Because they
I made written complaint for allegation of the unauthorized construction. Concerned Pradhan issued against me to scrutinize my sanction plan and my documents. Send notice. As per notice, I present there and made written submission. Page 89 onwards, my written submission, which also, my lord, received by the concerned Pradhan. If your lordship kindly see for a moment, page 89 and bottom, the Pradhan received the same. And page 91 is my specific allegation. If your lordship kindly say for a moment, page 91, para 5, that all on a sudden, in the year 2019, the private respondent number 8 illegally attempted to construct partly second floor pakka construction structure without taking any permission from the competent authority, and then and there the petitioner made objection for raising the same. Respondent number 8 shockingly did not stop the such unauthorized construction, and instead even atrociously completed the same in complete violation of the rules and regulation of the Panchayat law. And now, my lord, I am showing before your lordship section 23(6).
What is the order passed in the contempt proceeding?
Contempt, my lord, only notice has been served. Then Pradhan turned up and sent a notice for hearing, and contempt, my lord, the petitioner did not proceed, because after sending contempt notice, my lord called for a hearing by the Pradhan, and hearing has been done and order has been passed by the Pradhan. That was challenged before your lordship. And if your lordship kindly see for a moment at 23(6) what the provision speaks. My lord, 23(6) specifically stated that where any structure or new building or any addition to any structure or building is being or has been erected or made, as the case may be, in contravention of the provision of subsection 1, the authority may, after giving the owner of such building an opportunity of being heard, that was made by the Pradhan, make an order directing the demolition of the building by the owner within such period as may be specified in the order, and in default the authority may itself effect the demolition and recover the cost thereof from the owner as a public demand. This is specifically, my lord, 23(6).
They made the construction on my land, my lord. That is why Pradhan decided to measure them. They did not comply this. We assembled there. They did not comply this order. My lord, kindly see this order. And thereafter, my lord, no extra construction. Only extra construction is parapet, gatuni, and CD. My lord, my son is a cancer patient. That is why discrepancy arises, my lord.
Will be set aside.
My lord, I am for the state. My lord, if your lordship kindly come, page 98.
Page 98.
My lord, the permission was given in the year 1987.
Yes.
And my lord,
There is no dispute to that whether there is permission or whether there is no permission. Court has directed the Pradhan to assess whether there is legality and illegality in the construction made by the private respondent. What he has done is, he has not passed any opinion whether this construction is legal or illegal. He is waiting for the sanction plan to be produced by respondents. This is what is appearing. Court did not indicate that. Let him decide. I will set aside this order. Because this has not been followed. What has been directed by this court, this has not been followed.
Yes, the direction of the court must be followed and first the decision order be passed. within certain period.
He has to come to a finding that whether there is unauthorized construction. Yes.
Sanction plan.
Ashun.
My lord, my allegation, second
And
floor,
thereafter, my lord, kindly
second floor.
the
and
assembly they have
this.
to comply the measure to measure the land.
No, my lord, this is my land. I annex the, this is not the direction given by the Honorable High Court. This was not only regarding allegation unauthorized
This
if any sanction plan.
My land, my lord.
by the present writ petition, the petitioner
Number 23-6 has
has-
manner of application. Now after amendment, the matter is to be sent to the SDO under 23-5.
If your lordship kindly so desire, send the matter
will
SDO.
take decision relating to it.
No, no.
If the findings of the Pradhan is there, then there is no sanction plan and it is unauthorized.
Yes, yes.
Then on
Yes, you
subsection 5,
Yes.
subsection 5,
Five.
he will refer the matter to the SDO. No, Pradhan himself or Pradhan herself cannot demolish the
petitioner seeks for quashing and or setting aside of order dated 26th February 2024 passed by the respondent number 10 Pradhan Kamarpukur Gram Panchayat. Annexure P8. The petitioner contains that the private respondents undertook illegal unauthorized construction over which plot?
My lord, over, that is, I annex, described in my prayer portion.
Over
My
plot,
lord, that is page 14. Page 14, my lord, 1, 2, 3.
plot number 1216. LR plot number. Within bracket corresponding to RS Dag number 1137, comma, LR Khutian number 426. Moja Burisabha under PS Goghat. The petitioners made representation before the local Gram Panchayat on 13 January 2023 and 28th February 2023. Paragraph 1 to 3. এখন থেকে ওইটা করবে কিছু ছোট অর্ডার করতে হবে না কিন্তু Annexure P4. Since no steps were taken, the petitioner approached this honorable court by filing a writ petition being WPA 17296 of 2023. Next paragraph. The said writ petition was disposed of on 3rd October 2023 as follows, with the following direction. The writ petition, page 82. এই তিনটে প্যারাগ্রাফ the Pradhan having not taken steps in terms of direction passed by this court in the aforesaid writ petition, a content application was filed being now.
No, my lord, contempt application was not filed, only notice has been served. Then Pradhan issued hearing notice.
At that time,
Upon-
Panchayat election was there. That is why.
The Pradhan subsequent to a notice dated 19th January 2024. You were present in the hearing?
Yes, my lord,
Conducted a hearing in
I
presence of
submitted the written
petitioner
submission.
and private respondent and passed the impugned order. Please, Kara. Being aggrieved and dissatisfied with the impugned order, the writ petitioner has preferred the present writ petition. Miss Pompa Dhawal, learned advocate for the petitioner, submits that the Pradhan
Respondent number
10
10.
has not passed orders in accordance with the direction issued by the court.
7. 7. Respondent number 7. Pradhan is respondent number 7.
এই ওখানে ঠিক করে দিন প্রেয়ারের যেখানে বলছেন 10 বললাম প্রথমে there is mistake in the prayer.
Yes, my lord.
From the 7
7. It will be 7.
কি বললাম issued by this. Although the private respondents fail to produce any documents showing sanction of building plan, the Pradhan refrained from passing orders in terms of section 23(5) of the West Bengal Panchayat Act. She seeks for setting aside of the impugned order. And a direction upon the Pradhan to consider afresh in the light of direction issued in WPA 17 the number to বললাম
My lord, my prayer will be, my lord, if the entire issue sent to the SDO, my lord, SDO as per 23(5).
No. He has to comply, come to a finding that there is contravention of the 23(1). Thereafter, he will
1 and 3, unless it is determined and considered and referred to by the Pradhan, the SDO has nothing to do.
Mr. Lolit Mohan Mahata, learned additional government leader, submits that the Pradhan has to come to a finding regarding any illegality in the structures undertaken by the private respondents. In the event of any illegality, the matter has to be referred to the subdivisional officer in terms of section 23(5) of the West Bengal Panchayat Act. Mr. Swanshu, learned advocate for private respondent number 7, submits that the work of construction has been
Arvind Manna on behalf of private respondent number 7, 8.
undertaken with private respondent number 8 is in accordance with the permission granted by the local Gram Panchayat. There is no illegality in the next slide. This is second round of litigation. In the earlier round of litigation, in WPA 17 number to বসিয়ে দেবেন page number গল্পটা কোথায় গেল
My lord, that is page 81.
it was specifically directed that in the event the Pradhan is of the opinion that the construction has been made either in violation of the plan sanctioned or devoid of sanctioned plan, then necessary steps shall be taken to deal with unauthorized construction in accordance with law. The impugned order records that on the date of hearing, no such documents of any permission was produced. It is pertinent to note that the Pradhan, respondent number 7, has not passed any opinion as to whether the construction undertaken by the private respondent is unauthorized or illegal or in violation of sanctioned plan or not. Thus, it is found that the order passed is not in accordance with the direction issued by this court in WPA 17296 of 2023. Accordingly, the impugned order of respondent number 7 dated 26 February 2024 is set aside. The writ petition is disposed of directing Pradhan Kamarpukur Gram Panchayat, respondent number 7, to consider afresh upon hearing the parties the matter in the light of the direction issued by this court in WPA 17296 of 2023 and pass a reasoned order within a period of 4 weeks from date of communication of this order.
My lord, Dibati,
Present in the measurement proceeding, my lord, because their
No,
construction is
measurement-
on my land, my lord, according to our allegation.
my lord, only my prayer, my lord, Dibati may be given to correct the cause title on the address is, my lord.
So, on the prayer of what is the supplementary news and supplementary evidence. On the prayer of learned advocate for the petitioner, leave is granted to correct
Cause title, my lord, address of the cause title.
the cause title of the writ petition as well as prayer A of the writ.
Yes, yes. Grateful, my
Upon notice and hearing ওটা করে দেন। First reason order upon notice and hearing the party. চলো এবারে হ্যাঁ কমিউনিকেট করবে 4 weeks এর মধ্যে তো ওটা করবে from the date of communication of the order. হ্যাঁ 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 করবে। যেটা থাকে
Item 176.
But I am for the petitioner, my lord. My lord, yesterday, my lord heard the matter and case 53 was under consideration. My lord, may I place interesting, my lord?
have placed, he says that you are not eligible on that.
Case 53.
That is your report. You have filed your report.
Lord, just one thing. Lord, just one thing, my lord. My promotion has been withheld on the ground that one writ petition is pending and interim order is there. My lord, first of all, that interim order expired. Second is that person retired. Third is, my lord, that person
They will publish the notification, and as per their notification, if you are eligible, you will appear in the exam and you will be considered.
As per 2017 notification.
But that should be, my lord, within a certain period because I have lost my 4 years already.
When can this be concluded? Within which period the publication can be made? Everything is ready. Now the person who has retired, he has died also.
So far the document annexed with the writ petition.
Takes the আসুন।
I have seen everything in my report.
This writ petition is filed taking direction upon the respondent authorities to promote the petitioner to the post of lower division assistant under the general category as per the gradation list followed by the recruitment rules 1995. The petitioner contains that he when did you join?
Lord, I have joined. Just a minute, my lord.
Petitioner
On
joined
12th
12th
April
2010.
2010.
Joined as Group D staff in the office of North 24 Parganas, Jila Parishad on compassionate ground on 12th April 2010. As per the approval granted by the Panchayat and Rural Development Department, Government of West. Upon promotion of one Devasis Das, one vacancy against lower division assistant or clerk?
Lower division assistant.
May I submit one thing, my lord?
Lower division assistant.
May I submit one thing? Devashish Das also was not in the zone of consideration.
Was not.
No, because there was a requirement of at least 50% marks in the Madhyamik. He was not having that. He was not in the zone of consideration. Another two persons were zone of the participated in the selection process, but they are not selected.
His promotion to the post of LDA, that vacancy is there.
Vacancy is there.
So promotion to bad. Apna, the vacancy in LDA was created. The petitioner, did you apply? No.
I have applied.
Last,
The petitioner,
promotion
when did you apply?
was-
Let us have a check.
My lord, my first application is, my lord, on 1st June 2020.
He applied, the petitioner applied on
1st June 2020.
2020 for his promotion to the post of lower division assistant from the post of Group D. Since the petitioner was not promoted, the petitioner has filed the present writ petition. Learned advocate for the petitioner submits that he is the only candidate to be promoted to the post of lower division assistant under the general category. The petitioner made a representation on 25th August 2023. However, no decision has yet been taken.
Yes.
On the contrary, learned advocate for representing respondent number 4, Jila Parishad. Which Jila Parishad is this?
Not
North 24 Pargan Jila Parishad submits that on the date the vacancy was created, the petitioner did not complete 10 years of service as required in the notification under memo number 499/PN/O/Roman 3/2 capital E -62/09 dated 7th March 2017. The aforesaid notification also provides certain criteria which has to be made for getting promotion to the post of LDA. The petitioner has to qualify for a written test, appear for a written test and score 15 out of 50 in the written test. The promotion of the petitioner is not as normal followed in case of other posts. In case of a Group D employee for promotion to the post of LDA, the criteria as mentioned in the aforesaid notification has to be followed. The Jila Parishad upon direction by this honorable court, is ready and willing to publish a notification for conducting such test. Correct, sir?
I think my report.
Huh. Yes. Now he has completed the 10 years.
Yes.
Admittedly, the petitioner has completed 10 years of service.
Service, and I have 50% marks in Madhyamik examination. So I am eligible.
It is also not in dispute that at present the petitioner is eligible to appear for the examination which is to be conducted for promotion to the post of lower division assistant. Accordingly, the writ petition being numbered WPA 16939 of 2024 is disposed of, directing who will publish this? Jila Parishad will publish? Directing North Chobbish Pargana Jila Parishad to make publication of the examination to be conducted for promotion to the post of lower division assistant from Group D in terms of memo number such and such, 7th March 2017, within a period of 4 weeks from date of communication of the order. Learned advocate for the petition is directly communicate this order.
Entire process will be completed, my lord, within a certain period, because not only the notification, the entire process is there, my lord. That should be concluded
How can that
within
be?
a certain period.
Get a publication? Yes.
There are two categories. One is internship promotion and another is direct promotion. The ratio is 1:10. So why not kindly whisper internship promotion? Because
What a promotion from Group D, Inter-C promotion. बोल रहा हूँ Group D और Inter-C promotion. Publication of 4 weeks. Disposed of.
And entire procedure will be completed within 4 weeks.
How can that be? Publication, they will come, they will conduct a written examination, thereafter they will vote.
was on 27th. Again, approval is required.
Get the approval due.
That
My lord, Mr. Imtiaz Ahmed is appearing on behalf of the Mr. Imtiaz Ahmed is appearing on behalf of the petitioner. He's on his legs in court number 14, my lord. Kindly grants a passover. He is willing to the matter, and my lord, we want to find an exception.
Exception, yes.
My report.
Report has been taken on record.
My lord, we are willing to file an exception to the report filed by the respondent number 2 on the previous occasion.
Where is that?
My lord, I have that with me. আপনাকে সব করা হয়েছে স্যার এই তো আমি হ্যান্ড করব মানে kindly grants a passover
করতে চাই আমি
my lord, we have also served the state.
Exception to the report of the state filed by the petitioner is taken on record, copy served. Learned advocate for the petitioner seeks accommodation. Please this matter next week.
Grateful, my lord.
26th. 26.
26.
In this matter, I am the petition.
The state. What is the matter?
My name was in the list under the project of Pradhan Mantri Awas Yojana. In the my name was enlisted in the name, but subsequently, for reason not known to me, my name has been deleted. And as such, I made a representation to the DM and also
My lord, I have got the report.
district video.
He has a Pakka house, that is why his claim has been rejected.
My lord, this is my Pakka house. This is the photograph. देखो. No. Great special officer may engaged. পাক্কা হাউস দোতলা বাড়ি আছে তাদেরকে বাড়ি অ্যালট করেছে।
What is your name?
My name is Lalu Khan.
Lalu Khan, my lord, if you should kindly come, my lord, the third page of the report. Third page of the report, Lalu Khan.
332.
Yes, sir. Yes, my lord.
32.
No. 300.
332, serial number.
Under Banglar Bari.
334, my lord. My name, earlier list.
This is in respect of
334.
now in his family, his three brothers. Ilukfar Khan.
This is for the cancellation. He has got the Pakka house.
I deny the same, my lord.
File exception to this report.
A copy of the report may be serviced to me. No.
This one that it is in Pakka house.
Then I shall file exception of the report, my lord.
Any inquiry was conducted to find out?
Inquiry was conducted.
Where is that copy?
My lord, kindly see that, my lord, it has been signed by the executive assistant and the, my lord, the executive officer of the Panchayat Committee.
This is the report.
My lord, this is the, my lord, the cancellation report, my lord,
This is
page 1, 2, 3, my lord, if you are kindly see. Page number 3, my lord. Three 32. Borobuni, Lalu Khan, Jiyad Khan, ineligible Pakka house.
If you have Pakka house, then it will be dismissed.
Dismissed and my lord, and already my lord, it has been also been given.
no, my lord. I have
His
no.
other brothers. His
No.
other
The
brothers.
question of other brothers. I have the no Pakka house. This is my house, my lord. This is my house.
Front of any house and
Tile shed house.
the other brothers are considered as Bangla Bari.
They found eligible and they will get the my lord. Now the central scheme is my lord and is not granting my lord, so they will get the benefit of Bangla Bari. His brothers, but he will not.
Why not? I am eligible for the same, and my name was reflected from the earlier list.
Earlier list, that was my lord, inquiry was held and that it was held that the Pakka house is there.
It is
And all the name
it
was
is
the Pakka house. That has been cancelled.
no. I have no Pakka house. Then I have to file exception of the report.
What exception? The report is showing that you are having a Pakka house.
No, my lord. I have not a Pakka house.
You can deny. But having a Pakka house, how you are eligible for PMAY?
No. I have no Pakka house, my lord.
That is what you are saying.
Yes, my lord. This is my photograph of my house. Then an opportunity of giving me to file an exception of the report.
No opportunity. This is a misconceived writ petition.
My lord, they have submitted wrong a report, my lord.
Not only you have been made ineligible, all other persons are also made ineligible.
So
Not
many persons. So many persons. And my lord, his brothers.
My lord,
brothers
question
are-
of my brothers does not arise.
his
Whether I am eligible or not.
Found to be eligible in the my lord inquiry, his brothers, but not the petitioner.
I have only one small of land, nothing more.
Okay.
And my house is tile set, polythene.
File whatever report filed by the state is taken on record. Report filed by the state is taken on record and an advocate for the petitioner seeks to file exception. Fine. Next week. File an exception. Let such exception be filed.
Yes.
Within a week. This matter after 1 week, 26 or 27th day.
In 179.
এটা কাগজ ছিল না হাতে লেখা কাগজটা You have given a copy of 2005 decision? No.
2005 is
Yes. That is 2005.
Volume 2 SCC 436. Just 1 second. Just 1 second.
Yes. You need a copy?
Lord, I'm handing over.
This you refer to which paragraphs, Mr. Bhattacharya?
I have referred to Milord. Just 1 second, Milord. Milord, just 1 second. This is paragraph number.
Yes.
My lord, kindly allow me to submit my case, my lord. I have prepared one, my lord, written notes of argument supported by the judgment of the Supreme Court, my lord, 3 judges bench judgment, where it has been laid down, where in which cases, my lord, the equal pay or equal work for equal pay would be applicable. And my lord, the Supreme Court, my lord, categorically, my lord, given some guideline or frame, what is the actual work done and what would be the actual pay. That has been done. But in terms of argument, before that I will place to your lordship.
আমাকে একটা দিস।
হ্যাঁ দিচ্ছি।
তুই তো দাও না, আমি দিই।
তুই তো কৃপণ।
জাস্ট এক সেকেন্ড, আমি একটা কথা বলি না, একটা কথা। My lord, the judgment which I placed before my lords, that is 2005 volume 2 SCC 436. Lord, I think this will be 2006 volume 9 SCC page 321 paragraphs 15, 17, 19 and 20. My lord, I am handing over this judgment, my lord. Kindly 2006
volume 9
SCC.
I am relied upon.
Yes, yes.
I am relied upon.
Yes, yes.
I am also relied upon. I have annexed that judgment also in my written notes of
Paragraphs
argument.
15, 17, 19, 20.
Yes, 19, 20. I am relied upon 19.
I am grateful.
Before that, what is the my lord, the status of the petitioners? My lord, petitioners, they are working my lord Sahayo in different Gram Panchayat in a particular block. My lord, I will show to your lordship in my report, my lord, I could not file my lord affidavit in opposition. Only direction was to file report. In that report, I have annexed the recruitment rules. My lord, if your lordship kindly have a look into my report, method of selection of Sahayo, page 27.
Page 27
of my report.
Page 20.
Method of qualification required for recruitment to the post of Sahayok. Recruitment to the post of Sahayok after commencement of these rules. Well, this is the rules of 2007, my lord. Rules of page 24, 23rd March 2007. All petitioners are governed under these rules because their appointment after 2007 rules came into force. All the petitioners. So, my lord, their scale, my lord, A. My lord, scale is my lord, only my lord, consider the scale and grade pay. Otherwise, my lord, it is a very complicated thing. My lord. Scale is 5 and grade pay is 2300.
Scale is 5.
Scale is 5.
Scale number 5.
Yes.
Grade?
Grade pay is 2300. And thereafter, next page, page 28, qualification for direct recruitment. One must be citizen or such and such. Two must have passed the Madhyamik examination for the West Bengal Board of Secondary Education or equivalent education from the
Board of or Council of Union. Only criteria must have Madhyamik or class 10 pass, nothing else. What they are asking in the writ, they are asking for issuance of writ of mandamus for upgradation of their scale up to the post of secretary. That they have pleaded in different paragraph. Paragraph number 5, 6, they have pleaded. What is their case? They are asking our scale should be at par with the secretary of the Gram Panchayat. Kindly come to method of selection of secretary of the Gram Panchayat, page 26.
Secretary or the accounts clerk?
Well, all are, if your lordship kindly consider the grade, all grade are same. It starts from page 25, method of recruitment, qualification, grade. Secretary 5, serial page 26, serial number 5. Method of selection, recruitment director, thereafter kindly come to scale 6 and grade pay is 2600. So it is 6, scale 6 and 26. What is the qualification? Next page 27. Qualification C, skip up 1, Roman 2, must have Madhyamik from such as equivalent. This is same. In addition, desirable 6 months formal training in using personal computer for a recognized institution. So why this is scale 6? As they are specialized in computer. They are not. And their grade pay is 2600. So, it appears from the selection process that the qualification for recruitment to the post of secretary and Sahayok are different in nature. And I have given all other herein all other post recruitment method of recruitment has been specified. Why I am harping with regard to scale of secretary, because it is petitioner did not plead their writ petition the grounds for asking their upgradation of pay to the secretary. They have not pleaded. It's a very precise petition, but nowhere they have pleaded. Only even if your lordship kindly have a look into the prayer also, there is no specification. Prayer case 15 of the writ petition, writ of mandamus, each of them to remove the discrepancy in the scale of pay and in grade pay in same footing between different categories of employees in 3-tier Gram Panchayat Raj, considering the essential eligibility criteria for recruitment to the post respective post forthwith. I had already been demonstrated. They are asking writ of mandamus as recruitment are same in nature, but it appears from the recruitment of 2007 post of secretary additional qualification for 6 months computer training is desirable and essential, but Sahayok they are not, and that is why those persons, those candidates, they do not have requisite qualification of computer 6 months computer certificate. They opted for Sahayok. So it appears from the recruitment process rules that the secretary selection of secretary and recruitment of secretary are not same. In I will to refer to your lordship the nature of work done by the Sahayok and secretary. That is Gram Panchayat Administrative Rules 2004, Rule 55.
But then in this rules for recruitment, there is no mention of any accounts clerk or the other posts which are available in the Gram Panchayat. How do they be appointed? What will be their scale and what is the grade pay?
All are different. This is your lordship is absolutely right. All are different. This notification in respect of appointment of
executive assistant,
executive assistant,
Sahayok, secretary, and
Yes.
Sahayok.
Yes, they are asking with regard to the grade pay of secretary, because secretary scale is 2600. That is above the petitioner. Nirman Sahayok scale is different. Recruitment procedure is also different. If your lordship have a look, Nirman Sahayok scale is 10, page 26. Qualification is different. Diploma in civil engineer, C 2. Almost this requirement of recruitment of secretary and Sahayok are same. Only secretary 6 months additional computer course. But Nirman Sahayok is a civil engineer diploma is required, and petitioner do not have. And also executive engineer also scale grade space is 3600. Qualification diploma in computer application with institution, page 25. These are above the petitioners. These work is specifies there is specification that is not at par with the Sahayok. If your lordship kindly have a look, the duty of the Sahayok laid down in West Bengal Panchayat Administrative Rule 2004.
Page number is?
My lords will be pleased to get it from starts from page 5 to 5 to 4. The relevant portion, my lords will be pleased to find at page 534.
532.
Yes, 534.
Rule 55. Duties of the executive assistant of the Gram Panchayat. 2. Remain in executive charge of administration, including establishment, function, and financial operation of the Gram Panchayat. B. Be the custodian of the checkbook, passbook for the bank accounts, checkbook registered, and all entries by the executive assistant. Prepare check for enhancement of Gram Panchayat fund under the distribution of Gram Panchayat. Authenticate all entries in cash book. Perform perform the work relating to the implementation of programs, schemes. F. Preparation of annual budget. G. Supervision the preparation of amended list in respect of tax
H. Be responsible for allotment of duties of Gram Panchayat Kormi. I. Supervise recording on noting of the resolution adopted by the Gram Panchayat and Gram Sabha meeting. J. Procedure of checkbook register, passbook, such and such. Perform such other duties relating to Gram Panchayat and the state government may direct from 19. 55A. Secretary of the government is vital. Preparation A. Preparation of list in respect of tax and license fees live in the Gram Panchayat. Maintain cash book and books of accounts. C. Prepare the monthly, quarterly, half-yearly, annually statement accounts. Place the same before the Gram Panchayat. D. Assist the executive assistant towards preparation of budget of the estimated receipts such as such. E. Keep all records of Gram Panchayat in safe custody and produce the same in the meeting of the Gram Panchayat, Gram Sabha such and such. F. Oversee payment of wages of laborers engaged in various programs under implementation of Gram Panchayat. G. Record the resolution of the meeting held in the Gram Panchayat, Gram Sabha, Gram Samsad. H. Procedure all records before auditor of specification inspecting officer as and when required. I. Submit to the appropriate authority all grant in aid bills in due times. J. Perform duties of encashment of checks and disbursement of funds. K. Maintain all registers relating to all categories of Gram Panchayat employees. I. Perform such other duties in respect of work of the Gram Panchayat and of the state government as the Pradhan and Upapradhan of or state government may direct. There, my lord, kindly come to 55D. Duties of Sahayo. The petitioner's duty. A. Assist the executive assistant in the matter of financial administration is if and when required. Assist the secretary to facilitate the proper maintenance of accounts and records, including vouchers of financial transaction made in by the Gram Panchayat or encashment of check. So, my lord, it appears he would be, my lord, acting as to assist, my lord, the secretary, not at par with the secretary. C. Assist the secretary in recording the resolution of the meeting held in the Gram Panchayat, Gram Sabha, such and such. D. Any other duties as may be assigned by the Pradhan state government. So, my lord, only 3 duties are specified. One is to assist the executive assistant. 2 is to assist the secretary in proper maintenance of accounts. C. My lord, assist the secretary in recording resolution of the meeting. And D is, my lord, common. So, my lord, these 3 types of duty would be, my lord, featured that the duties and responsibility of Sahayok not at par with the secretary of the Gram Panchayat.
But in the writ petition, nowhere they have claimed that they are claiming parity with pay in respect of secretary only.
Secretary.
Only secretary.
Otherwise, my lord, secretary is the only, my lord, scale 6. But assistant and executive officer, scale 10 is the higher. And there is, my lord, recruitment, there is specification, diploma in engineering, civil engineering. So, my lord, above the, my lord, petitioners, above the Sahayok, there is only secretary. Secretary is getting 2600. My lord, I am satisfied to demonstrate to your lordship, only they can claim at par with the secretary. My lord, it appears from the Gram Panchayat administrative rules, duties of the secretary is vast duties. Bank, maintenance, check, others, all are vested to the secretary. But duties to the Sahayok only to assist the secretary and executive assistant, nothing else. So, my lord, I will demonstrate the, my lord, judgment of the Supreme Court. Supreme Court also, my lord, said categorically, before passing any order, court must see the nature of duty assigned to the particular block of employee. That is, my lord, guideline of the Supreme Court. So, my lord, I have demonstrated to your lordship the duties of the secretary and duties of the Sahayok are not same. And, my lord, executive assistant and other executive they are very high and they have the specific qualification. They are not entitled to claim other at par with other 7 except secretary. That is why I will show to your lordship secretary and Sohayok are not same. My lord, I have in my written notes I have given all things, the method of recruitment of executive assistant. I have given everything, secretary, Sohayok. I have given everything. I have narrated. Then I have given rules specified 55 classified duties of the different secretary, assistant secretary, job assistant, Nirman Sohayok and Sohayok. Only I am referring to your lordship Sohayok and secretary because these two qualifications are almost same. Only secretary have must have 6 months qualification. Then kindly come to the judgment referred by my senior friend. Also, I am relied upon that 2006-9 Supreme Court case 323 paragraph number 19 and 20. তোমার কাজ কমিয়ে দিলাম। May I please?
Yes.
19. Having considered the authority and submission, we are of the view that the authorities in the case of Jasbir Singh, such and such, Odisha, such and such, lay down the correct law. Undoubtedly, the doctrine of equal pay for equal work is not an abstract doctrine and is capable of being enforced in court of law, but for equal work has no mechanical application in every case. Article 14 permits reasonable classification based on qualities and characteristics of persons recruited and grouped together as against those who were left out. Of course, the qualities and characters must have a reasonable relation to the object sought to be achieved. In service matter, merits or experience can be a proper basis of classification for the purpose of pay in order to promote efficiency in administration. A higher pay scale to avoid stagnation or resultant frustration for lack of promotional avenue is also an acceptable reasons for pay differentiation. The very fact that the person has not gone through the process of recruitment may itself in certain case make a difference. If the educational qualifications are different, kindly mark it. If the educational qualifications are different, then also the doctrine may not have may have no application. It would be applicable in this present case. If even though persons may do the same work, their quality of work may differ. Where persons are selected by a selection committee on the basis of merit with due regard to seniority, a higher pay scale granted to such persons who are evaluated by competent authority cannot be challenged. This is my case, my lord. A classification based on difference in educational qualification justifies a difference in pay scale. That is my submission. A mere education qualification, a mere nomenclature designating a person as say a carpenter or a craftsman is not enough to come to conclusion that he is doing the same work as another carpenter or craftsman is regular service. The quality of work which is produced may be different and even nature of work assigned may be different. It is not just a comparison of physical activities. The application of principle of equal pay for equal justice work requires consideration for various dimensions of a given job. The accuracy required and dexterity that the job may entitle may differ from job to job. it cannot be judged by the mere volume of work. They may be qualified different as regard responsibility and responsibility. Function may be same, but responsibility may be different. Well, kindly consider it. Thus, normally the applicability of the principle must be left to be evaluated and determined by an expert body. These are not matter where a writ court can lightly interfere. Normally, a party claiming equal pay for equal work should be required to be raise a dispute in this regard. In the event, the party who claims equal pay for equal work has to make necessary abatement and prove that all things are equal. Thus, before any direction can be issued by a court, the court must first see that there are necessary abatements and there is a proof. If the High Court is, on the basis of material produced before it, convinced that there was equal work for equal quality and all other relevant factors are fulfilled, it may direct payment of equal pay from the date of filing the respective petition. In all these cases, we find that the High Court has blindly proceeded on the basis of the doctrine of equal work applies without examining any relevant factors.
We'll continue tomorrow. কালকে continue করবে হ্যাঁ কি থাকবে তো করবে দেখে দিন written notes of argument keeping today, or you can take it back. Tomorrow I'll continue.
Kindly keep it. I have already given him a copy, but kindly record it.
Since I'm not recording any order today, we will continue
Okay.
tomorrow. That's why I'm handing it over. Kindly take the pen to hand over tomorrow.
My lord.
Next week.
I'm so sorry, but because I was ready and very good.
Okay.
Exception has been filed.
Okay.
Looking at the clock,
We'll try to do that.
I was ready with the matter, but I was arguing about
Let it come up on 25th or 26th.
it. I'm so good. I'm so not sure.
Come in the next week. Let it come up.